Associate Justices, Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business for the Honorable Supreme Court of the Philippines shall give their attention. Court now in session.
The clerk of court will please call the matter at hand.
GR number 213948, Knights of Rizal versus DMCI Homes Incorporated, DMCI Project Developers Incorporated, City of Manila, National Commission for Culture and the Arts, National Museum, and National Historical Commission of the Philippines. Appearing as amici curiae are the following: Attorney Johnson V. Domingo. He's the Acting Executive Director, National Building Code Development Office. We have Engineer Agustin S. Torres, Consultant, NBCDO. We have Architect Emmanuel P. Contapay, former Executive Director, NBCDO. And Attorney Antonio M. Bernardo, Chief Executive Officer and Commissioner, HLURB. Appearing as counsel for Petitioner Knights of Rizal, we have Attorney William L. Hazarino. Appearing as counsel for Respondent DMCI Homes Incorporated, we have Attorney Basilio D. Gascon Jr. Attorney Pasio is not around. Counsel for Respondent DMCI Project Developers Incorporated, we have Attorney Roberto Endio, Attorney Leonid C. Nolasco, Attorney Victor P. Lazatin, and Attorney Stephen George S.D. Aquino. Appearing as counsel for Respondent City of Manila, we have Attorney Jose Alberto C. Flaminiano and Attorney Luis E. Del Mundo Jr. Appearing as counsel for Respondent NHCP, we have Attorney Jose Manuel I. Jocno and Attorney Jose E. Delisay III. From the Office of the Solicitor General, we have Solicitor General Florin T. Hilbay, Assistant Solicitor General Vida G. San Vicente, State Solicitor Marie Christine R. Nolasco Jimenez, Associate Solicitor Ivan M. Bandal, Associate Solicitor Emerson S. Banyes, and Associate Solicitor Gerardo E. Mendoza. Honored.
Councils will please take their seats. Attorney Hazarino. Can you please address the court regarding the manifestation you filed?
Yes, Your Honor. This representation filed the manifestation regarding the observation by the Honorable Velasco regarding the use of the word building in lieu of the word billboard. The manifestation was filed yesterday, Your Honor, please.
Effect that?
Well, to the effect that the Honorable Justice was correct.
Okay. Thank you, Attorney
Thank you, Your
Hazarino. Attorney Lazatin, may we find out if there has been any pleading or manifestation filed with respect to the claim regarding the Manila Hall of Justice?
Yes, Your Honor. We are going to be filing a manifestation within the next few days, Your Honor. We've been able to identify certain proclamations, Your Honor, where President of the Philippines transferred the properties, the ILI, which was intended for the Supreme Court, to the GSIS, and also proclamation number 835, where former GSIS property was transferred to
But
Supreme
with
Court.
respect to the proposed structure, is there anything that you will file with us on
We
the
were
matter?
able to identify the contractor, Your Honors, and we have been trying to get a certification from them. The contractor, Your Honors, is ITF Construction / Advanced Foundation Construction Systems Corporation joint venture, Your Honor.
Okay.
Have requested for a certification. The fact that from 2001 to 2004, they have done board filings as well as file capping, Your Honor, of the different columns, Your Honor, or bold files. In fact, we have also photographs of the site as of the present, and it shows several concrete columns, Your Honors, that have been are already at the first or second floor level, Your Honor. And we are also aware, Your Honor, that a original certificate of title number 11008 was issued in favor of the Supreme Court, but this is in connection with the GSIS property, Your Honor. We are also aware that a certain architectural engineering firm was hired, TechFil, to do the design for the Hall of Justice that was supposed to have been built on the Hialeah, on the old Hialeah site, Your Honor, and that is TechFil. We are also trying to get a certification.
Attorney Lasati, we will need to know how the Supreme Court participated insofar as the design of that building is concerned. So it is appreciated that those documents be filed with us at the earliest possible time.
Our understanding, Your Honor, our inquiry indicated that the contracting party, Your Honor, was the Department of Justice. And it is my understanding is that once the buildings are completed, they are turned over to the Supreme Court, and it is the Office of the Building, Office of the Halls of Justice, Your Honor, that will administer these properties, Your Honor.
Okay, I will do what is necessary from my end to find out to what degree we participated in the conceptualization of that building. Thank you. But we
Thank you, Your Honor.
need that to be forthcoming as soon as possible.
Yes, Your Honor.
The Attorney Manuel Jokno, please. You confirm that you received the clarification made by the Solicitor General on his representation?
Your Honor,
Yes.
a manifestation.
And then you have not filed the position paper. I just want to make sure for the record that the NHCP has no position paper as of today.
As of yet, Your Honor.
Okay, thank you very much. So we will resume the interpellation of the City of Manila. Attorney Flaminiano, kindly approach the podium, and Justice Hardeleza will resume his questions.
Thank you, Chief.
Good afternoon, Your Honors.
Good afternoon, Counsel.
Good afternoon.
And thank you for sending us all the documents we have requested. You sent us one of the documents, the legal opinion of Attorney Renato de la Cruz, City Health Officer,
City Legal, Your Honor.
Officer, I'm sorry. Dated September 19, 2011. And among others, it chiefly says, and this explains the practice during the term of Mayor Lim. And I quote, letter to Resti Rebong. Clearly, there is no categorical provision limiting the height of buildings.
Yes, Your Honor.
Do you have it before you, Counsel?
I'm should have it, Your Honor. I have it with me, Your Honor.
As I was saying, Counsel, this explains the practice during the term of Mayor Lim, the city legal officer in an advice to Rebong CPDO said, and I quote, "Clearly, there is no categorical provision limiting the height of buildings.
Yes, Your Honor.
Even your reference to the so-called floor area ratio FAR in the ordinance does not stand to constitute a hard and fast rule on height, on building, on height limitations." And then Attorney De La Cruz ends by saying the determination of whether or not a structure is illegal rests with the city engineering office, the building official, and the city planning and development office. Do you confirm that?
Yes, Your Honor.
Yes.
That is what is contained in the last sentence of the letter,
So
Your Honor.
this legal opinion of the legal officer of Mayor Lim also explains why, and as you said and confirmed by the minutes of an MZBAA meeting, December 10, 2009, which confirms that during the term of Mayor Lim, there was only one MZBAA meeting
Meeting,
held.
Your Honor. Yes, as shown by this minutes, Your Honor.
Yes, and the highlight of that meeting was they took up the MZBAA primer, right?
Yes, Your Honor.
So during the whole term of Mayor Lim, the MCBAA was not functional.
It was not, Your Honor.
And so, and I guess that's the reason why when you came in or with the term of President Mayor Estrada, you changed the procedure.
Yes, Your Honor.
You submitted to us Executive Order number 30, where Mayor Lim reconstituted the MCBAA, right?
Yes, Your Honor, on September the 18th, 2013, Your Honor.
And that brings us now to the practice. Last week, and so you obviously disagreed with the procedure of the past administration.
Definitely, Your Honor. It was, the process actually was incomplete so far as we were concerned, Your Honor.
So last week, Mr. Lacuna informed us that there was this letter from DMCI, right?
Yes, sir.
The December 18 letter.
September 18 letter, yeah.
Now, but 2 weeks before, he had met with DMCI persons and briefed them on what was needed, right?
That was Architect Lacuna's declaration before the court, Your Honor.
Yes. May I flash for you on the screen section 61 and 62 again of the ordinance? Section 61 on procedures for granting variances and exceptions
Yes,
says
Your Honor.
there has to be a written application for an exception.
Yes, Your Honor.
Citing the section and stating the grounds, right? I noticed that the letter of DMCI does not, well, in fact, is not a written application for an exception. It is a request for assistance, right? It does not state the section of the ordinance.
Yes, Your Honor.
It does not state the grounds, therefore, right?
Yes, Your Honor.
Now, there was also this 2-week period when there were ex parte communications between Mr. Lacuna and
Asho, Your Honor.
the
DMCI
DMCI,
representative.
right?
Yes, Your Honor.
Now, we understand the meaning of ex parte communication, meaning just the two of them, right?
Just the two of them, Your Honor.
Now, I'm sure you're familiar with the jurisprudence on bodies like the MZBAA. These are assessment and appeals boards, right?
Yes, Your Honor.
So they are essentially quasi-judicial bodies, right?
Your Honor. Yes, Your Honor.
And as quasi-judicial bodies, nevertheless, I think you informed us last week that the MZBAA does not have rules, IRR, internal rules and regulations.
None that I know of, Your Honor.
Yes, not that you know of.
Yes, Your
Therefore,
Honor.
I submit to you that at the very least, the default rules should be contained in the rules of procedure as I outlined in the administrative code. or as outlined in the case we're very familiar with, Ang Tibay versus Court of Industrial Relations.
Yes, Your Honor.
You will agree with that?
Yes, Your Honor.
Do you have any other default provisions that guide?
I don't think we have any other default provision, Your Honor.
So,
We relied mainly on what 8119 and its IRR contains, Your Honor.
no, so during this period from November 18 to, I'm sorry, from December 18 to December 23,
Yes, Your Honor.
when the board issued its ruling, you did not give any notice to other parties.
No formal notices that I know of, Your Honor.
Where there were notices to the members of the board, right?
Yes, Your Honor, for the meeting, the 23rd of December
Yes.
meeting, Your Honor.
But
But
I
not
mean,
to
there were-
private entities or parties, Your Honor.
What I mean, there were no notices to outside parties, to the public. For example, no notice to the cultural agencies.
None, Your Honor. None that I
No
know.
notice to Mr.
Except, perhaps, Your Honor, the what appears in number 2 of Section 61, the posting of a visible project sign where the project site is, Your Honor.
Was a notice posted
I
on the
was
site?
made to understand, Your Honor, that such notice was posted in the project site, Your Honor. Other than that, I would not know of any other notice sent to other parties, Your Honor.
Now, I noticed the resolution that was signed by the members of the board granting the variance.
Yes, Your Honor.
This would constitute more or less the decision of a quasi-judicial board, right?
We agree, Your Honor.
Yes, that's your decision.
Yes,
And
sir.
yet, a while ago, we mentioned the rules of procedure of the Administrative Code of the Philippines, or as I said, at the very least, the rules, the 7 cardinal primary rules of Ang Tibay versus Court of Industrial Relations. We noticed that the grant or the decision does not state the law and the facts. In fact, it doesn't state that this is an application for a variance. It doesn't state what are the grounds for the variance, what are your findings of fact. It just says, it's granted based on the submissions, right?
I agree with the observation of His Honor.
And there is no record, there is no transcript in case somebody appeals on which there is a record for which an appellate court can look at the proceedings, right?
I don't believe there was a transcript, Your Honor, but perhaps minutes of the board meeting, Your Honor.
I'm
But
sorry, are there minutes other than
I
what
would
have been
believe so,
submitted?
Your Honor, but not transcript, I suppose.
Are there minutes other than the resolution itself?
I think there is, Your Honor.
And I would appreciate if you can send
We
it
will
to the
provide
court,
the court with that
by the
copy.
next week.
But not, I don't think there was any transcript. I'm not sure, Your Honor. I will check with the city planning office.
That resolution number 6, I believe, was that published or circulated to parties?
I don't believe so, Your Honor.
Now, one of the points of the DMCI is that the Knights of Rizal could have appealed to the HLURB, one of the provisions of the rules of the HLURB
Yes, sir.
pertains to appeals from boards like MZBAA. Was the Knights of Rizal or any of the cultural agencies furnished with a copy of
I don't believe
resolution?
so, Your Honor.
You don't believe so. And that is why, Council, I laud the efforts of the new administration to reconstitute the MCBAA, but I have grave problems of due process. And now that we are at it, about the rule of law. With all of those admissions of yours, the process was marked by lack of notice. There was ex parte communication, continuous ex parte communication between the applicant and who was the grantee. 61 was not followed. Of course, after 61, Section 61, it was submitted to the City Council.
I would have to say, Your Honor, that the procedure we relied upon which is Ordinance 8119, Your Honor. I have to concede it is imperfect, Your Honor. It's not a perfect ordinance, but we had nothing else to rely on except this ordinance, Your Honor.
No, I just have one last question. Now, the original application for the building permit was filed July 5, 2012, and it was issued on the same day.
My notes indicate that the building permit, Your Honor,
The building
was
permit.
issued July 5, Your Honor, and the application was filed on the same day, Your Honor.
Same day.
Yes, Your Honor.
To your knowledge, during the previous administration, was that the practice, consistent practice?
We have not looked into that, Your Honor, so I will not be able to give.
What about now?
I also wouldn't know the time within which an application is processed, Your Honor, how long it takes for a building permit to be processed.
I have no other questions, Chief.
Thank you very much, Your Honor.
Thank you.
Justice Carpio.
Council,
Good afternoon, Your Honor.
let's go to the ordinance 8119. For residential condominiums that are standalone, in other words, not part of a commercial complex or an industrial complex,
Yes, Your Honor.
the FAR is uniform for the entire city of Manila at FAR 4, correct?
I believe so, Your Honor.
So it's
FAR 4.
FAR 4 for all residential condominium buildings that do not form part of commercial complex or industrial projects.
There might be the FAR might be different when it comes to condominiums in commercial areas, Your Honor.
Yes, I'm talking of standalone
Yes, yes, Your Honor.
residential condominiums.
Uniform
Okay.
FAR 4, Your Honor.
And the percentage of land occupancy is always
60%.
60%.
Correct, Your Honor.
Okay. That is why, how many square meters is this Torre de Manila? Is
They
the
applied
footprint of the land?
7,000.
It's about almost 3,000.
The land area, Your Honor, it's
The-
almost 5,000. 5,556.
So it's almost half a hectare.
Yes, Your
And
Honor.
at FAR 4, it can only build up to 18 stories. I mean, at FAR 4. Is that correct?
If the 60% of the
Yes, but
land
that is the rule.
Rule, that's the rule, Your Honor.
60%
of the land
will
area.
be buildable, the rest not buildable.
Yes, Your Honor.
Okay? So, if you look around here in the city of Manila, anywhere you go, you look at standalone residential condominium buildings.
There's a lot of them, Your Honor.
It's always not FAR 4, it's more than FAR 4.
Yes, Your Honor.
And the buildable area is to the edge of the property. It's not 0.6, it's not 60%, correct?
Yes, Your Honor.
So, if you look at all the commercial residential buildings in the last 10 years, they are all variances. They did not follow the original FAR 4
That-
or the 60%. Every residential building that stand alone was a variance.
That's correct, Your Honor.
So the rule really in city of Manila is variance, and the exception, which is never followed, is FAR 4. You agree with
It
me?
appears to be that way.
That is really the situation,
Yes,
correct?
Your Honor. Yes, Your Honor.
Why is this? Why, in other words, I'm the developer, I bought a land, I bought 1,000 square meters, I put up a residential condominium building, I can only build 2 stories because
The restriction.
that's the FAR 4, and I have to build it only on 600 square meters.
Your Honor.
That's correct.
Yes, Your Honor.
Okay? So, I will have to go to the city council to get a variance, correct?
That's correct, Your Honor.
So, why does the city council want every developer to go to the
To
city
them.
council and ask for a variance? Why?
I really cannot say, Your Honor.
You cannot say.
Why?
You don't have an idea? Okay. Isn't it the function of the city mayor to approve or disapprove the building of a residential condominium? What is happening now, since every developer will go to the city council, the executive function of approving or disapproving is now exercised by the city council, correct?
Yes, Your Honor.
Why does the city council want to exercise this executive function?
That
What's in it for them?
I
You do not
won't
know.
be able to say, Your Honor.
So that is the business model in the city of Manila. You agree with me?
Yes, Your Honor.
Every developer will have to
Must.
get a variance because it doesn't make sense to follow FAR 4 because the land is so expensive, and if you can build only 2 stories on a 1,000 square meter lot, you will surely lose money, correct?
Exactly, Your Honor.
You agree with me completely, correct?
Completely, Your Honor.
Isn't that sad? I mean, every businessman will have to go to the city council and practically ask for a zoning ordinance for his particular lot.
Perhaps, Your Honor, as I've said earlier, the ordinance is imperfect.
Isn't
Your Honor.
the ordinance invalid because it's the executive function is now exercised by the legislative body?
That question has been raised before, Your Honor, in some other forum, but no definitive ruling has
What
been...
is the role of the city mayor now if there's a application for variance? You only recommend.
Recommend to the council, Your
Yes,
Honor.
recommend to the
As
council.
the chairman of the zoning board.
The zoning board will just recommend, but
It's
it's
up to the
supposed to
council
be the
to-
function of the mayor as the executive official, correct?
Yes, Your Honor. That's true.
There is something terribly wrong. You agree with me?
I would tend to agree with this honor, sir.
During the prior administration to
Yes, sir.
Mayor Estrada,
Mayor Lim, Your Honor.
yes, during the administration of the predecessor of your mayor, how do you characterize it? Is it, you said it was incomplete, correct?
Complete or defective, Your Honor.
Effective. Is it illegal?
Uh,
Did it violate the ordinance?
yes, Your Honor.
So it violated the ordinance in the sense that it had to have a variance approved by the Sangguniang
Yes,
Panlunsod.
before
Is that
the zoning permit was issued.
And
Yes.
the Sangguniang Panlunsod can only approve it if there is a recommendation of the zoning board,
Board,
of,
yeah.
adjustment,
That's right, Your Honor.
etc.
Yes, Your Honor.
Correct? So it was illegal.
Yes, Your I can say that, Your Honor. I
Yes.
would
So
say
that the construction was illegal also.
That can be concluded, Your Honor, if...
Yes. Are you familiar with Section 3J of the Anti-Graft and Corrupt Practices Act?
yes, Your Honor.
Yes. It
But
actually
I
says
would not
this,
recall the exact
J,
wordings of the...
that any public officer is liable for the following. J, knowingly approving or granting any license, permit, privilege, or benefit in favor of any person not qualified or not legally entitled to such license, permit, privilege, or advantage. You're familiar with that?
Yes, Your Honor.
So do you think that the administrators prior to your term could have been or are liable for these acts?
Perhaps, Your Honor, but I respectfully would like to decline from issuing a conclusion with... they could
that's
have had
fair. But
the
at the very
reasons,
least-
Your Honor.
That's fair, but at the very least, you would say that the zoning clearance and the
There seems to
building,
have been a violation.
a violation and illegal, correct?
Yes, Your Honor.
Can it be corrected by ratification if it was null and void because it was illegal?
Your Honor, we actually did not consider it, the zoning permits, as invalid or illegal. That's why I mentioned earlier, Your Honor, I described
let
the
me
zoning
just
permits
clarify
as
again, step by
incomplete or
step.
defective, Your Honor.
You said that it violated an ordinance, correct?
Yes, Your Honor.
Yes. If it violates a law,
From one point of view, from one perspective, Your Honor.
if
But
it violates a law, what is your submission? What is your legal submission? If there is an act that violates a law, therefore,
it
do we
confers...
recognize that it exists? The act itself.
No, Your Honor.
Okay. Ignorantia legis non excusat. Can you translate that into English?
The law excuses no one from compliance therewith.
So it does not excuse the former planning officer, correct?
If they have no justifiable
Yes.
reason or
It
valid
doesn't
excuse, Your Honor,
also
for
the legal
issuing the
officer
zoning.
that they
I'm
did
sorry.
not know the provisions of the ordinance, correct?
I
Ratified that particular zoning clearance by belatedly processing a variance 2 years hence. Is that correct?
Yes, Your Honor.
Yes.
We completed the process, Your Honor.
So I would appreciate that in your memoranda, these questions be covered.
We will do that, Your Honor.
Okay. Was there an ordinance that was passed which allowed a visual corridor for the Rizal Monument?
I remember the ordinance passed during the time of Mayor Lim, which was vetoed.
It was vetoed.
8310,
So,
Your Honor.
what is the effect of a veto of an ordinance that is passed by the Sangguniang Panlunsod?
Doesn't become law, Your
It
Honor.
doesn't create an ordinance, correct?
Yes, Your Honor.
Was there an override of that ordinance?
I'm not sure, Your Honor. My records would not show.
Is there an existing ordinance after that one?
None, Your Honor.
None.
Similar with similar provisions, Your Honor.
Okay.
I am not
Yes.
aware of any ordinance
Yes.
with similar provisions.
Okay. So therefore, there is nothing preventing the creation or the building of a building at the back of the Rizal Monument, and it does not violate any ordinance relating to visual corridors. Is that correct?
That's correct, Your Honor.
Yes. Is there a
Not
law
present.
that prevents the building of that kind of a building at the back of the Rizal Monument? A law?
Our research, Your Honor, shows that we found no law prohibiting the construction of Torre de Manila where it was constructed, Your Honor.
Okay. A while ago, in answer to Justice Carpio, you said that this is the system in all parts of Manila in relation to commercial residences.
Not only in commercial,
in residential areas. Is that not correct?
yes, Your Honor, but including also, for example, Your Honor, the Taft Avenue area.
Yes.
It's also considered as part of
So you are saying that
university
the city
cluster.
of Manila granted zoning clearances with variances without the approval of the Sangguniang Panlunsod in all of these cases?
Not during our time, Your Honor. I would have a list of the buildings in the Taft Avenue area, tall buildings, Your Honor, which were built during the time of other mayors, Your Honor.
And you would provide
And
this
I-
court with a list.
Yes, Your Honor, we will
Is
provide.
it a substantial number of buildings?
I would say so, Your Honor.
So all those buildings were constructed without the proper zoning clearance being taken for their construction.
That is what our records or
So all
initial
those buildings
research
were
indicate, Your Honor.
constructed illegally.
Believe so, Your Honor. In violation of the zoning ordinance, Your Honor.
By the way, what is the petition that was filed in this case? What is the nature of that
It
petition?
was a petition for injunction, Your Honor.
Petition for injunction, but now what is the existing vehicle or remedy?
For mandamus, Your Honor.
A mandamus petition.
Yes, Your Honor.
And from the allegations of the petition for mandamus now, what is it that is supposed to be the ministerial duty of Manila? Because you were impleaded as a party.
We do not really know, Your Honor, what is that ministerial duty on our part.
Is the nullification of an ordinance being prayed for in this petition?
No, Your Honor.
Is the nullification of a building permit being prayed for in
No,
this
Your Honor.
petition?
It's actually the
Is
demolition
the
of the...
nullification of a zoning clearance issued on July 2012 being prayed for in this petition?
There is no such prayer, Your Honor.
Is there a prayer asking that the ordinance be declared unconstitutional because the legislature is being asked to perform an executive function?
I'm sorry, Your
Is
Honor.
there a prayer to declare as unconstitutional a part of the ordinance on the ground that the legislature is performing an executive function?
There is none, Your Honor.
None in the prayer in the petition, of course.
I don't recall having read... my recollection of their prayer is that they're asking for the demolition of the Torre de Manila, Your Honor.
And is the city of Manila being told that it has the ministerial duty to demolish?
No, Your Honor.
What is the act or what is the duty that you're supposed to perform in
Oh.
order to accomplish the demolition?
We do not know. From the petitioner's standpoint, Your Honor,
Yes.
We do not know, Your Honor, what they're asking us to do
What if,
as a ministerial duty.
according to your manifestations in oral arguments, that this is not a standalone case, meaning to say it is not the only time that a zoning clearance was issued without the proper approval of the city council, that this is a habit, this is pervasive in the city of Manila. To correct this, is it proper to file a petition for mandamus in the Supreme Court?
I don't think so, Your Honor.
Can you cover this in your memoranda? And I would also appreciate the other parties
We will do so, Your
to
Honor.
also cover this, most especially the petitioner. Principally, the question is, can we grant a relief that has not been prayed for in the petition?
I don't believe so, Your Honor. I don't think the Honorable Supreme Court would do that, Your Honor.
Why?
That's, it would cause an injustice, Your Honor. It
Why
will be
is
in
it an
violation of
injustice?
substantive and procedural laws, Your Honor.
What procedural law? What substantive right?
Substantive right, Your Honor, the right to be heard of the parties.
Due process.
Due process.
Because then we would be putting up an argument which was not there
Yes, Your
in
Honor.
order to favor one party.
Yes, Your Honor.
And the other party has not been given the chance
Chance
to respond to
to,
it.
yes, Your Honor.
Yes. By the way, at this stage, can the petition still be amended?
At this,
At this stage?
at this stage, I don't think so, Your Honor, because a lot of arguments have already been given,
Can the
and it will
Supreme
be
Court,
unfair to the respondents, Your Honor.
can the Supreme Court, motu proprio, change again the nature of the petition to one of certiorari or prohibition?
I don't believe the Supreme Court will do that, Your Honor.
Why will it not do that?
It will cause injustice to the
Again, what
respondents.
is that injustice that will be committed?
So it will be a gross violation of procedural and substantive law, Your Honor.
Yes, but clarify this to me, counsel.
Like procedural law, I understand, Your Honor, that there are times when on matters of national interest, the Supreme Court may suspend its rules, especially rules on procedure, Your Honor, to facilitate the administration of justice. But in this case, Your Honor, I think it will cause a lot of prejudice if the Supreme Court suspends the rules and just accepts, receives evidence from, like us, Your Honor, the councils of
But we are the Supreme
Responded.
Court. We are the Supreme Court.
yes, Your Honor.
And according to some statements made to the media by some of you, some of the parties, which of course will be read by members of this court, the statement is we can do practically anything we want. Is that true?
That is not correct, Your Honor.
Really?
We believe that the Supreme Court is also bound by the rule of law.
The rule of law.
Yes,
Thank
Your
you,
Honor.
counsel.
Thank you, Your Honor.
No, I will not ask any que- Justice Velasco.
Good afternoon, Your Honor.
Good afternoon, Council. I just want to ask some questions for clarification. Ordinance, resolution number 121 enjoins the city building official to temporarily suspend the building permit of Torre de Manila.
Yes, Your Honor.
City Council of Manila says enjoin. What do you mean exactly by enjoining the building official? Being the legislature in the city, it does not have power over the city building official, correct?
That, in a way, Your Honor.
So, what do you mean? You must have been exposed to a lot of resolutions
Yes.
of the City Council. So, is the City Council of Manila merely requesting or asking the city building official to temporarily suspend? Is that the
Perhaps
the meaning of this?
Perhaps the council meant request, Your Honor, because if we interpret the word enjoin here as it is used in injunction or prohibition cases, Your Honor, I don't think that's the intention here.
Okay, so you're
It
saying...
it is meant to persuade, perhaps, Your Honor, the building
Okay.
official to.
So they're just requesting, they cannot compel
They cannot, Your Honor.
the building official to suspend the building permit of Torre de Manila.
They cannot, Your Honor.
Okay, you're now the city legal officer, correct?
Yes, Your Honor.
You have read the September 12, 2012 advisory from the then City Legal Officer Renato de la Cruz, correct?
Yes, Your Honor.
Have you studied this carefully as the incumbent or current City Legal Officer?
May I just look for my copy, Your
Okay,
Honor?
refresh your memory or really go over it.
I already have it, Your Honor.
Okay,
Thank
you have
you,
that. Okay, the first paragraph says,
Please advise.
first page, first paragraph, it
Yes, Your
says, this advisory stems from your request. Is this, what do you mean by advisory? It's just a recommendation to the building official from the office of the city legal officer?
I think it's used as a synonym for opinion, Your Honor, the word advisory.
It's an opinion, okay.
Yes, Your Honor.
So, the city legal officer gave an opinion on the subject matter of Resolution 121.
Yes, Your Honor.
Okay, go to page 2. Go to page 2.
I'm on it, Your Honor.
All right. It states there is no showing that the subject property has been officially declared as an anthropological or archaeological area. Did you find out if this is correct? That the subject property has not been officially declared as an anthropological or archaeological area.
Yeah. One of my staff in the City Legal Office, Your Honor, has submitted a paper to me with the same observation. That
What paper is that? Did
it's
you
an
submit
internal memo, Your Honor.
in your memo?
Yeah,
No, but
in,
did you study
inter-office
this?
memo, Your Honor.
Did you study if this is correct? The finding, is this a finding of the former city legal officer? You're referring to, what is this subject
Anthropological.
property? Is that the Rizal Monument? We're referring to the Rizal Monument, right?
Yes, Your
Park.
Honor. Yes, Your Honor. Because the next
Correct.
sentence refers to National Historical Institute Heritage Zone, Your Honor.
And
So-
who declares a certain structure or a certain area as anthropological or archaeological
Perhaps the
area?
National Museum, Your Honor. I'm not quite sure, Your Honor.
You're not sure?
It's
I
the
thought you
National
studied
Museum.
this.
We will, Your Honor. We will.
Okay, please study that because this is the basis for the inaction of the building official.
Yes, Your Honor. We will
Second
include.
line
Yes, Your
of
Honor.
the fourth paragraph. Neither has it been categorically designated by the National Historical Institute as a heritage zone, a cultural property, a historical landmark, or even a national treasure. Have you studied this? Have you consulted the National Heritage Institute?
Your Honor, there's a resolution dated 1995 which declared the Rizal Park as a National Historical Site, Your Honor.
By the National Historical Institute.
Yes, sir. And then there's also an issuance declaring the Rizal Monument National Cultural Treasure, which was issued by the National Museum after this opinion was issued, Your Honor.
So you're saying that Renato de la Cruz, former city legal officer, was correct in
Yeah.
stating that the Rizal Monument and the Luneta Park has not been categorically designated by
At
the
the
National
time-
Historical Institute.
Yes, at the time this was issued in 2012, Your Honor.
So at the time, as of September 12, 2012,
2012, Your
this
Honor.
has not yet been declared as a heritage zone, cultural property, historical landmark, or even a national treasure. Okay?
Yes, Your Honor.
Lastly, the last sentence of that paragraph, it says, indeed, it is not among those listed in the registry of the Philippine cultural properties of the National Commission for Culture and Arts. Is this correct?
I have to admit, Your Honor, I was not able to check the accuracy of this statement, Your Honor.
Okay. Then the next paragraph says, This notwithstanding, none of the concerned cultural agencies has issued a cease and desist order against the project in accordance with Section 25 of RA number 166. Who are these cultural agencies that have the power to issue a cease and desist order under
The-
Section 25?
The National Historical Commission of the Philippines, Your Honor.
So
The
there-
National Museum. These are the cultural agencies, Your Honor, referred to in Republic Act 166, Your Honor.
Can you state that again? You're saying there are two
Yes, Your
government
Honor. The
agencies that
National,
can issue a CDO?
insofar as national treasures are concerned, Your Honor, the National Museum, Your Honor. And, Your Honor, can I just go through my notes? I made some notes about this. Your Honor, the agencies that may issue CDOs, Your Honor, are the National Historical Commission of the Philippines with respect to when the issue pertains the physical integrity of cultural properties, Your Honor. The National Museum with respect to when the issue pertains to the physical integrity of monuments, and the NCCA, or National Cultural Commission for the Arts, Your Honor, in instances involving World Heritage Sites and works of national artists, Your Honor. So there are three agencies, Your Honor,
So,
who may issue
with respect
CDOs.
to the Rizal Monument, you're saying there are three government agencies
I'm sorry,
that can issue the
Only two, Your Honor.
CDO. Only two,
The NHCP and the National Museum, Your Honor.
NHCP and the National Museum.
Yes, Your Honor.
Okay.
But only when it only involves the physical integrity, Your Honor, of the monument or the structure.
Okay. Did you find out, as the successor of City Legal Officer Renato de la Cruz, if as of September 12, 2012, there was a CDO issued by either the National Museum or the National Historical Commission of the Philippines?
I don't think there were any CDOs issued at that time, Your Honor. It was only lately, Your Honor, that on January 5, 2015, that NCCA issued the CDO, Your Honor.
It was NCCA.
Yes, Your Honor, that issued the CDO.
But a while ago you said it's NHCP and the National Museum which
The-
can issue the CDO.
Yes, Your
Now
Honor.
you're saying it's NCAA?
It was NCAA that issued the CDO, Your Honor. But
Is
based
it-
on our readings, Your Honor, and our interpretation of the provisions, it's only the NHCP or the National Museum that may issue CDOs, Your Honor.
No, but
The
under
NCCA,
Section
under the
25
rules,
okay.
may issue CDOs with respect to properties, cultural properties declared as World Heritage Sites or works of national artists, Your Honor. The Rizal Monument is not any one of these, Your Honor.
Section 25 of RA 166 says the appropriate government agency to
Yes,
issue
Your
a
Honor.
CDO.
Yes, Your Honor.
So it refers also to the NCAA.
Yes, Your Honor, but the NCAA is limited to issues involving World Heritage Sites and works of national artists,
Yes,
Your
but
Honor.
we're referring to the, of course, the Rizal Monument
Yes,
and the
Your Honor.
Luneta Park. So can NCAA, has it the power to issue a cease and desist order?
Based on the rules, Your Honor, it is not empowered to
It
do
has
so.
no power.
Yes, Your
Uh-huh.
Honor. Yes, Your Honor.
And you studied that very well. Okay. Ordinance number 8310 is described as the Historical and Cultural Monuments Preservation and Protection Ordinance of the City of Manila, correct?
That was vetoed by Mayor Lim, Your Honor.
Did this proposed ordinance did not
Become law, Your Honor.
become a law or did not become an ordinance,
Ordinance,
right?
Your Honor. Yes, Your Honor.
Because then Mayor Alfredo Lim vetoed the ordinance.
Yes, Your Honor.
Okay. So right now, at present, is there any ordinance in the City of Manila that protects and preserves cultural, historical, and cultural monuments inside the city?
There is none, Your Honor, but I was told by Architect Laguna in one of my discussions with him that presently we are in the process of updating our comprehensive land use plan, Your Honor, and these heritage and cultural issues are seriously being considered, Your Honor, and for some provisions to be incorporated into that revised or updated comprehensive land use plan, Your Honor. But
You mean
no-
to tell me that the intention is to integrate these provisions which are intended to protect and preserve the cultural and the historical monuments
That's
to be
the idea, Your
integrated in a zoning and land use plan?
That's the idea, Your Honor.
That's the
To
idea.
adapt,
Is that
these
normally a
guidelines.
part of a zoning and land use plan?
I'm not so sure, Your Honor.
Okay.
These are just plans, Your Honor.
All right. So it was because of the opinion of City Legal Officer Renato de la Cruz that the building official at that time did not do anything regarding the requested temporary suspension of the building permit. Is that what happened?
Yes, Your Honor.
Okay. All right. That's all.
Thank you very much, Your Honor.
Justice
Just
Peralta.
clarification, because
Good
most of the
afternoon.
questions, most of the questions that was about to ask were already asked by my colleague Justice Hardilesa and Justice Marbig. Just two questions,
Yes, Your Honor.
clarification. So there is a difference between ratification and variance. But there is a difference between ratification and variance.
Your Honor, if I may explain. Variance refers to the floor area ratio and the percentage of land occupancy, Your Honor. When a developer applies for any of this, for exemption, for variance, this is what will be ratified by the council, Your Honor. The recommendation of the zoning board, Your Honor.
So it is the variance that is ratified.
The application, the recommendation of the board, Your Honor, of the zoning board, regarding the application for variance, Your Honor.
No. Okay. I'm still confused, no? Because I am referring to the first part of Section 63. It refers to variance, eh?
Yes, Your Honor.
It does not speak of ratification, eh? It does not provide for any ratification. That's why I'm asking for clarification.
Your Honor,
The Section 63 provides that the variance should take place before the construction starts. That's what I
even
remember
before the
already,
zoning
yeah.
permit is
So it
issued.
does not speak of ratification. It's not provide for any ratification.
It's,
So what I understand from variance is that if your plan is already submitted, then before you start the construction and you want to revise the plan, then you make use of Section 63 for the variance of the plan. That's what I understand. That's why the provision states that it should be done before construction. Eh?
yes, the plan doesn't necessarily have to be revised, Your Honor. If the plan is, like in the case of Torre de Manila, if the plan is to build 49 stories, Your Honor, and that would be beyond the allowable FAR of 4, for instance, Your Honor, then they apply for variance.
Yeah, that's correct.
For them
So
to
you-
be allowed to build higher than
you
what
apply
is.
for a variance. There is no yet ratification to speak of.
The application, Your
No,
Honor.
you just,
No,
just,
not yet,
I will
not yet,
ask you
Your
a
Honor.
follow-up question kasi I'm a little bit confused. Eh.
Yes, Your
So
Honor.
that is variance.
Yes,
The plan
Your
has already been submitted, but you want to introduce a variance on the plan before the start of the construction.
Yes, Your Honor.
Then you have to apply for a variance is attaching therewith the plan. Eh. The rule requires, the provision requires that it should be accompanied by a plan.
Yes, Your Honor.
Yeah, okay. So
Yes,
I'm
sir.
still accurate. I'm
Yeah.
correct. Okay. And then the application for variance will go to the appeal board.
Yes, Your
This
Honor.
is headed by the city mayor, but delegated to the, in this
Secretary to
particular
the
case-
mayor.
Yeah. So what will be approved, what will be recommended by the board is whether or not the variance will be approved by the city council.
Sanggunian,
Yeah,
yes, Your
so
Honor.
it will be approved. So if it will be approved, then you make the variation.
Yes, sir. That
where
is the ratification process, Your Honor.
No, just wait for my question.
Yes, I'm sorry, sir.
So where is the ratification? What does it ratify? What does the council ratify?
The recommendation of the board, Your Honor.
Is that not approval? Why DHS has to ratify? What does it
That's how they
ratify?
term it, Your Honor. You cannot...
Yeah, because I'm reading, or if I can if I remember right, the resolution of this council does not use the word approve the variation eh. Ang nakalagay doon eh, ratify all the licenses that have been issued eh.
Yes,
You
Your
look
Honor.
at it. I'm not reading from the resolution, but I'm still young eh. And I think my memory is still correct eh.
Yes, sir. Yes, Your Honor.
Yun, di ba? Ratify all the licenses already issued eh. Hindi
Yes, Your Honor. That's the
sinasabi,
last paragraph of the
per the
resolution.
variations. I'm not putting any blame on any of the officials. In fact, from the appeal, the one that was prepared by the appeal board, headed by Attorney Serapio,
Yes, Your
they
Honor.
followed the rules on variation eh.
Yes, Your Honor.
They followed the rules. Mayroon risk
Like-
management dyan. They consulted the adjacent owners of the property. It is
everything.
stated there eh. They
Yes.
really followed eh.
Yes, Your Honor.
The steps to be taken in variation eh. That's why I'm confused. Why do you use the word ratification when it's all about variation eh?
If
You
I
look
may-
at you read the recommendation of the appeal board. It's all about variation eh. Even the letter of Mr. Austria addressed to the city mayor eh. He likewise stated in the letter eh, variation din eh. Even in the first part of the resolution of the office, that there is a problem on the far of the building. Nakalagay sa first part ng resolution and the PLO and so
Yes, Your
on.
Honor.
By virtue of the recommendation of the appeal, the licenses and permits are hereby ratified.
I apologize, Your Honor, if I use the word ratification. I cannot find the word ratification here in the resolution, Your Honor. It's approval of the...
Your appeal board really followed the procedure. The only problem is if there was if it could act on that request for a variance at that point in time. That is the
Yes,
problem
sir.
eh.
Yes, Your Honor.
The variance was made already the latter part of latter part of 2013 eh.
If I
And
may
then the city
respond...
council came out first, I think January of 2014 with that resolution.
Yes, sir. If
The
I may...
building was already there.
Yes, Your Honor. But when during the time of Mayor Estrada, Your Honor, the city had two options available to it regarding the project of Torre de Manila, Your Honor. Either impose the penalty on Torre de Manila under the ordinance 8119, Your Honor, which is 5,000 pesos, or imprisonment of 1 year, or both, whichever is higher, or allow, as we did, Your Honor, DMCI to complete the application process, Your Honor.
So now I am clarified, Attorney Flaminiano.
Thank
So
you.
it was actually a variance, not a ratification. They ratified the license, but it was requesting
sir.
for a variance, and that's what your board did. Eh.
Yes,
it was
Your Honor.
actually variance. Eh. They followed what's provided for on the provisions, the proper steps in acting the variance. The only problem is that the variance took place too late.
Yes, Your Honor.
Because should be when the work started, or when the construction has started.
Yes,
Di ba?
sir.
But the view of Justice Carpio is that there's something wrong with the ordinance because it is the council that acts on variation.
That's correct,
So
Your
it is
Honor.
the council that enacts the ordinance, but at the same time it is the council that acts on variation.
Yes, Your Honor.
Okay,
We
thank
will
you.
bring this to the attention of both the City Council, Your Honor, and the Executive. Perhaps,
Okay, thank you very much.
Thank you, Your Honor.
I have just one question that was provoked. Tuloy ko na, itutuloy ko na. That was provoked by one of your statements saying that in the case of the in the case of the Rizal Monument, it is only the National Museum and the National Historical Institute, now the National Historical Commission of the Philippines, that can issue a cease and desist order.
Yes, Your Honor.
So,
That's our reading of the law, Your
yes,
Honor.
does it have anything to do with Article 2, Section 3J of the National Cultural Heritage Act of 2009?
I just...
Can you please look at your version?
Your Honor is referring to 186, Your Honor.
Uh,
Public Act 186, Your Honor.
National Cultural, yes, RA 10066.
166, Your Honor. And
Can you please go to Article 2, Section 3J?
L2. Cultural agencies, Your Honor.
Those are that's the definition portion, right?
Yes, Your
Can you
Honor.
just read the chapeau of Section 3?
Cultural agencies shall refer to the following national government agencies with their specific areas of responsibility. The National Museum, open and close parentheses, cultural property. The National Library, with respect to books. National Historical Institute for Philippine History. National Archives for documents. Cultural Center of the Philippines for culture and the arts. And Komisyon sa Wikang Filipino for language, Your Honor.
So your version of the law is the same as mine. I cannot read National Commission on Culture and the Arts here.
It is not found here, Your Honor.
It is not found there.
Yes, Your Honor.
Now, in other words, the National Commission on Culture and the Arts is not defined as one of the cultural agencies under
That-
Section 3J
Yes, that's
of
correct.
Article 2.
That's correct.
Now, what does Section 25 of the same
Same
act
law.
provide?
Speaks of the power to issue a cease and desist order, Your Honor, which is when the physical integrity of national cultural treasures or important cultural properties are found to be in danger of destruction or significant alteration from its original state. The appropriate cultural agency, meaning, Your Honor, those enumerated in paragraph J, shall immediately issue cease and desist order, ex parte suspending all activities, etc., Your Honor.
Is the fact that the power to issue a cease and desist order only confined to the cultural agencies under Section 3J of Article 2. Is that the basis for your view that the cease and desist order with respect to the construction of the Torre de Manila is not within the powers of the NCAA? Is that the reason why
It's not
you were...
within the power of NCAA, Your Honor.
Okay, thank you. At least I'm
Thank-
clarified.
Thank you, Your Honor.
So, Justice De Castro.
Good afternoon, Your Honor.
Good afternoon. I just have one or two questions. The rest of my questions will be addressed to the National Historical Commission. Now, I just want to be clarified about resolution number 5 issued by the council, and this is dated January 16, 2014. It says here in the preambulatory clause, the last preambulatory clause, whereas the members of the City Council of Manila find no cogent reason to deny and or reverse the aforesaid recommendation of the Manila Zoning Board of Adjustment and Appeals, MZBAA, and hereby ratify and confirm all previously issued permits, licenses, and approvals issued by the City of Manila for Torre de Manila. Now, therefore, it approved the recommendation of the zoning
Zoning
board.
Board, Your Honor.
So it would seem that there were already permits, licenses, and approvals before this resolution was issued.
Yes, Your Honor.
So the variance was not approved before the issuance of...
No, Your Honor. This refers to the zoning permit and the building permit that were issued during Mayor Lim's time, Your Honor, without going through the process of the zoning board appeals process, Your Honor.
And that would already cover the variance.
When they applied for, when the MCI applied for variance, Your Honor, that is what I meant when I said we completed the process of application, Your Honor.
So there were already approvals and permits and licenses issued even
Before.
even before it passed through
Yes, Your
the,
Honor. Yes, Your Honor.
Okay. So that is why the term used here is ratification,
Ratification,
and
Your Honor.
confirmation.
Yes, Your Honor.
Okay, that's all.
Thank you, Your Honor.
With that, you are hereby discharged.
Thank
We'll
you very
now
much,
call
Your Honor.
on the Solicitor General.
Your Honors.
who represents the National Commission on Culture and the Arts and the National Museum. Sir De Leza.
I believe the Soldier may want to make an opening statement, Chief.
All right. Please proceed. How many minutes will your statement consist of as delivered, to be delivered?
Around 14 minutes. Around 14 minutes. 1-4.
All right.
Madam Chief Justice, Honorable Associate Justices, good afternoon and may it please the Court. The two important questions in this case are as follows. Whether the physical integrity of the Rizal Monument is impaired by the presence of Torre de Manila. Whether the permits issued by DMCI from the City of Manila are valid. These questions can be resolved with basic tools of constitutional analysis and statutory interpretation, and the facts based on the documents submitted by respondent DMCI and the City of Manila. Allow me, Your Honors, to state the various components of our arguments. Number one, the Constitution enacts conservationist and protectionist policies with respect to the Rizal Monument, a cultural treasure of the nation. Number two, the statutory mandate to protect the physical integrity of cultural artifacts covers the protection of the sightline of the Rizal Monument. Number three, the zoning and building permits of DMCI were issued ultra vires in patent violation of Ordinance Number 8119, Section 60, 61, 62, 63, 65, and 69. This is the Rizal Monument. This is the Rizal Monument with Torre de Manila. When the Constitution declares that the state shall conserve the nation's historical and cultural heritage, we believe that it means what it says. That is, to conserve the Rizal Monument, we have to go back to this. Constitutional policies perform very important functions. They admonish all government institutions, in particular Congress, to enact enabling law to transform such policies into detailed, enforceable mandates. They provide both meaning and interpretive direction to the language of the law. They declare a sense of national priority, and they instill a sense of normative consciousness, even duty, on citizens. We take it as a given that the cultural artifact that is the Rizal Monument in Luneta is part of the cultural treasure of the nation, regardless of any formal declaration. There can be no doubt that of all the monuments of our national hero, and perhaps even of all monuments in this country, the Rizal Monument in Luneta is primus inter pares. It is sui generis. The Rizal Monument in Luneta is kilometer zero by virtue of EO 487. It is one of the most recognizable historic sites in the Philippines and an almost mandatory stop for visitors from the provinces and even those from abroad. Our desire to protect it is so overwhelming, it is guarded 7 days a week by the Philippine Marines. It is the site where our national heroes' remains are buried. It has formally been declared by the NHCP as a national monument, by the former National Historical Institute as part of a national historical site, and by the National Museum as a national cultural treasure. These facts undeniably make the Rizal Monument in Luneta a prime object of the Constitution's conservationist and protectionist policies under Article 14. The demands of conservation of cultural artifacts depend on the nature, the physics, if you will, of the object being protected. The physics of a painting, for example, require that it be placed in a temperature-controlled environment so that the paint will not be vulnerable to changes in temperature and exposed to the elements. Thus, the way to conserve a painting is by controlling the temperature of the environment in which it is located. In some cases, you may have to tamper with the physics of the artwork itself in order to restore it, as was the case with the frescoes in the Sistine Chapel. On the other hand, the conservation demands of certain old documents mean that you cannot even touch them or expose them to sunlight or moisture. To conserve them means, for all intents and purposes, to hide them from public view. The point here, Your Honors, is that there is no universal standard for protecting the physics, or in the language of RA 166, the physical integrity of a cultural artifact. In other words, in the area of heritage conservation, the integrity of the physics or the physical integrity of an object has a flexible attribute. This is how experts view the practice of conservation, and it is not unreasonable to read that understanding into the law. The language of the law, therefore, can and should be made to accommodate this concept. The rational way to do this is by giving the term physical integrity a broad meaning to promote the policy of the law and give it practical value. Which brings us to the question, is the physical integrity of the Rizal Monument impaired by the presence of Torre de Manila? Yes. The Rizal Monument, as a cultural artifact protected by the Constitution and our heritage laws, is a visual phenomenon that exists as an integrated unit. This includes not only the bronze sculpture and the accompanying obelisk, or the motto stela, but also the ground and the space in which it is located. The Rizal Monument, as an artwork, was intended to be and has always been seen with a clear sightline. One, therefore, cannot divorce the motto stela from the park in the same way that one cannot divorce the motto stela from the sightline. The physics of the Rizal Monument is such that the obelisk, the bronze sculpture, and its sightline constitute a single piece of cultural heritage. Put otherwise, the integrity of the physics that requires preservation is the unity of those parts that create the cultural artifact that is now the Rizal Monument. Thus, if the way to conserve a painting is by controlling the temperature of its environment, the way to conserve the Rizal Monument is by preserving its sightline. So when we speak of the Rizal Monument as a cultural artifact that the Constitution has endeavored to conserve and protect, we are talking about the Rizal Monument as we see it. Viewed as such, that necessarily includes its sightline. Let me stress, Your Honors, that I am not making an argument based on aesthetics, even if that argument can obviously be made. We are making a purely legal argument that seeks to resolve the question whether the Rizal Monument's physical integrity includes its sightline. At the constitutional level, this is a case about the meaning of the conservationist and protectionist policies of the Constitution. At the statutory level, it is about the meaning of the term physical integrity. As a matter of legal hermeneutics, it is about the interaction between constitutional policy and statutory language. The court is confronted with two interpretive choices. It can either interpret the physical integrity of the Rizal Monument as referring to just the motto stela, a restrictive interpretation, or to the motto stela and its accompanying sightline, a broad and rational interpretation. We believe, as a matter of law, that the Honorable Court should choose the latter interpretation because this is the interpretation consistent with the physics of the Rizal Monument as an integrated unit, a unified piece of cultural artifact. This is the interpretation that will give practical meaning to the conservationist and protectionist policies of the Constitution. And applying the precautionary principle in environmental law by analogy, when human activities may lead to threats of serious and irreversible damage to cultural heritage, action shall be taken to avoid or diminish that threat. Let me go now, Your Honors, to the legal status of the permits issued by the City of Manila to DMCI. I have very limited time, so I'll go straight to the conclusions we can derive from the documents on record. Number one, the City Planning and Development Office had no authority to issue the zoning permit it issued. This is clear from Section 63 of Ordinance 8119, which grants the CPDO authority to issue zoning permits only for all conforming uses. By the standards of Ordinance 8119, DMCI zoning permit is invalid because it goes way beyond the floor-to-area ratio. Whereas the ordinance allows only a floor-to-area ratio of 14, the zoning permit allowed 13. Whereas Torre de Manila should have been entitled to a maximum of 7 floors, its application was for 49 floors. This is 42 floors beyond the authority of the CPDO. Number two, Ordinance 8119 is also clear about which institution has the authority to issue the permission for variance or exception from the ordinary zoning rules. It is the Sangguniang Panlunsod or City Council, as per recommendation of the Manila Zoning Board of Adjustments Appeals, or the MZBAA, through the Committee on Housing, Urban Development, and Resettlements under Section 60 of the ordinance. Following Section 63 of Ordinance 8119, this should have been done prior to conducting any business activity or construction on their property or land. The issuance of a zoning permit is no guarantee of its validity. Why? Because the ordinance itself says so. Under Section 65 of the ordinance, the issuance of a zoning permit or locational clearance shall not be construed as an approval or authorization to the permittee to disregard or violate any of the provisions of this ordinance. These defects also taint the validity of the building permit and the business permit. According to Section 69 of the ordinance, no building and business permit shall be issued by the local building officer and business promotion and development officer, respectively, without a valid zoning permit or locational clearance in accordance with this ordinance. Given these facts and conclusions of law, what is apparent is that DMCI was less than prudent, both in securing the required permits and in building Torre de Manila. A diligent developer would have gone through the required processes under the ordinance. It would not have built Torre de Manila with undue haste. Let me emphasize, Your Honors, that my task here is to apply the law to the meager but undisputed facts of this case, not to impute any illicit motives on our public officials and on DMCI. Nonetheless, with respect to the Torre de Manila project, we can only say, perhaps generously, that DMCI has assumed the risks to which it is now exposed. Had it actually followed the rule of law, it would not be facing the danger of loss it now confronts. Your Honors, allow me to make some final remarks on the procedural posture of this case. If you will recall, our consolidated comment in this case recommended the dismissal of the petition based on its technical deficiencies and our initial reading of the merits. But the resolution dated June 16, 2015 of this Honorable Court, issuing a temporary restraining order, and even more, setting the case for oral arguments, has given us the opportunity to take a second look at the merits and eventually reconsider the government's position. We are therefore thankful that the Honorable Court has bestowed upon this case the appropriate attention and importance it deserves, which we admittedly have initially overlooked. Mindful of the power of the Honorable Court to dispense with procedural barriers in order to reach substantive justice, the Office of the Solicitor General, as Tribune of the People, now asks the Honorable Court to declare that Torre de Manila impairs the physical integrity of the Rizal Monument, and that it issue all appropriate reliefs to restore the Rizal Monument to its prior condition. Consequently, the government is asking the Honorable Court to order private respondent DMCI to demolish Torre de Manila, an illegal construction, to the extent that it impairs the sightline of the Rizal Monument. It also asks the Honorable Court to order the City of Manila and/or the concerned national agencies, by way of continuing mandamus, to oversee the demolition of Torre de Manila and provide the necessary reports to this Honorable Court until such time that its judgment is fully enforced. Thank you.
Justice Herdaleza.
Thank you, Chief. Good afternoon, Mr. Soldian.
Afternoon, Justice Herdaleza.
My first question is, I don't think you made a categorical statement on the status of Article 15 of the Constitution. Is it or is it not a self-implementing provision?
We do not believe, Your Honor, that it is a self-implementing provision of the Constitution.
And if it is not self-implementing, what implements Section 15?
What implements Section 15, Your Honor, are all the heritage laws that we have right now, in particular 166, 186, and all other related laws.
So your position would be 15 is not self-implementing, and it is being implemented in terms of a statute passed by Congress, all the heritage laws. And I call your attention to Republic Act 166 and Section 25. Your theory is physical integrity includes the protection of the sightline.
Our theory, Your Honor, is that as a general principle, we can and we should interpret Section 25 to include, in certain cases, the protection of the sightline of a monument when it comes to the protection of its physical integrity, as a general matter. And as applied to this particular case, given that the Rizal Monument has a sightline, that general application should be made with respect to the Rizal Monument.
Yeah, so again, just to clarify, again, the sequence is you are not staking a claim that 15 is self-executing.
No, Your Honor, in fact, we believe that the law itself has been passed and that law sufficiently implements
Yes,
Section
and
15.
just to clarify, for the avoidance of doubt, you cite many heritage laws, but we can focus on, at the very least, you are pointing to one statute passed by the Congress, RA 166. You are finding support in Section 25, which says physical integrity, but you have your proposed reading of Section 25. And therefore, under your theory, 166, specifically Section 25, implements Section 15 of the Constitution.
In fact, Your Honor, all the laws, and I have here a long list of laws that implement the constitutional policy.
Well, in your memo, I would appreciate if you will also explain in detail how the other laws, in your view, implement Section 15.
Yes, Your Honor. If I may, Your Honor, I can give a short explanation.
Go ahead.
The language of the Constitution is rather sparse: conserve and protect. And so, by way of implementing the sparse language of the Constitution, the Congress saw in fit to pass RA 7356, RA 4368, 186, 166, RA 3477 to expound on the constitutional meaning of the term conservation.
My second question Mr. Solgen, is now you are citing all the heritage laws, and I am suggesting to you at the very least Republic Act 166. Now,
Yes, Your Honor.
on another level of law, city ordinance, doesn't ordinance of the City of Manila 8119 also implement Section 15 in that directly or indirectly, by putting a limit to FAR, the ordinance in effect indirectly, in the case of the disputed area, an implementation, a way to ensure a sightline?
Absolutely, Your Honor. In fact, if we look at the structure of the laws that have been passed, there appears to be a confluent jurisdiction on the part of the national agencies and the City of Manila. So the national government has its cultural agencies as well as the NCCA under Section 25 and the local government code. The local governments are, in fact, the frontline agencies when it comes to the protection of our cultural heritage. And so you have layers upon layers of articulation of the constitutional principle here, Your Honor.
Thank you, Mr. Solgen. My next question is very specific to Article 25, and this was asked by, I think, some of the members of this court already. In your view, under Section 25, which of the cultural agencies are given the power to issue a CDO?
Your Honor, the RA 166 enumerates all the cultural agencies. They are the ones that have the power to issue CDOs.
So this will include the National Museum?
National Museum, NHCP, with reference to this particular case.
How about the NCCA?
If you look, Your Honor, at the deliberations, apparently there was an intention on the part of, I think, Senator Angara to include the NCCA in the matter of issuing CDOs. But the language of the law, in particular the specific enumeration of the statute, appears to have excluded the implementation of that particular intention of one member of Congress.
So what is the answer, Mr. Solden? What's the position of the government? Does the NCCA have CDO powers under 25, having read? And I have read also the minutes of the BICAM, the discussions between Senator Angara and Representative Chong. Bottom line, what's the position of the government on Section 25 and NCCA?
Well, under Section 25, the NCCA does not have the power to issue a CDO. Although I noticed, Your Honor, during the interpellation, you in particular, Your Honor, seem to be thinking of the power to issue CDO on the part of the NCCA on grounds other than Section 25.
Well, Mr. Solden, you have not yet answered my question. Bottom line, does the NCCA have powers to issue a CDO wherever sourced?
Our answer, Your Honor, is no.
Now, on the reliefs, Mr. Solden, your view is that this court is empowered to issue an order directing the demolition of the Torre de Manila.
Yes, Your Honor. If it is an illegal construction, as it clearly is, then it would be strange for the court to not have the power to issue any appropriate relief, right? To enforce an order of the Supreme Court, in fact.
I will cite to you just one question of fact, which in my mind has not been settled, Mr. Solgen. A while ago, a member of this court said that under the ordinance 8119, even without a variance, the DMCI can build up to 18 floors or 18 stories. That is of record. That is also the position of the DMCI. Before any variance, therefore, before any violation of the ordinance, they're entitled to 18 floors. A while ago, your position is that before a variance under the same ordinance, FAR 4 entitles the DMCI only to, is it 7 or 8 floors?
7 floors, Your Honor.
7. And I believe, and I stand to be corrected, but I believe the petitioner in the first session of the court stated Knights of Rizal's position is that the maximum number of floors under FAR 4 is, I believe, 8 or thereabouts. Mr. Azarino, am I correct? Your position is under the ordinance 8119. How many floors will FAR 4 translate into?
Our position, Your Honor, is 7.
7. So there's a position of 7, there's 8, there's 18. My question to you, Mr. Solgen, this court is not a trier of fact.
Yes, Your Honor.
Wouldn't that unclarity about a question of fact still has to be resolved somehow, somewhere by a court other than this court?
Absolutely not, Your Honor. The formula is not a question of fact. It is a legal matter. And the formula is lot area times FAR over lot area times PLO. And computing that with respect to the lot area of DMCI, that is 7 stories, Your Honor. And so that is not a question of fact.
I am afraid, Mr. Solgen, that this is where DMCI introduced into these proceedings the concept of footprint. My understanding of a footprint is the lot maybe, I think it's almost 7,000, almost 8,000 square meters. If you build totally on it, you build on 8,000, but you're allowed only 60%. But the footprint may actually be smaller. And that's why I understand from the position of the DMCI that their footprint is, I think, less than 4,000. I'm sorry, can we have it, Mr. Lasatin?
Print, Your Honor, is 1,837.
Yeah, so with a footprint of 1,000, less than 2,000, they are also computing 18. So I believe, and I posit to you, that is a triable question of fact, which, to my mind, is an argument against this court making a decision for the total, for the declaration of the total demolition at this point.
Again, Your Honor, I'll repeat my answer. Absolutely not. It's a question of what proper formula should be applied. And I remember during the interpellation of private respondent DMCI by Justice Diosdado Peralta, he seems to have agreed to the rather basic and simple formula of Justice Peralta. I think the notion of a footprint is a rather disingenuous way of creating some semblance of a question of fact. DMCI has all the right to present their theory, their proposed formula in their memorandum, but I think, Your Honor, we're rather confident with the rather straightforward application of the formula that we present.
Well, I am sure, so Mr. Solgen, that you fully believe that your formula is straightforward, but I can predict that when DMCI files its memo, they will also have a very vigorous argument for an equally straightforward computation, and your computation will be different from theirs and different from that of the Knights of Rizal.
That is fine, Your Honor, except that what we are saying is that whatever formula the court will accept in its decision is not a question of fact. It's simply an application of law. It's a choice between what we believe is the standard formula in Ordinance 8119 and what their concoction might be of the appropriate formula might be. It's simply a choice between two options, not a question of fact.
Thank you, Mr. Soljan. Another
Thank you,
question
Your
that I
Honor.
have is, I think I have explained when I interpolated counsel for DMCI, is that this court took the step of converting the petition for injunction into one for mandamus based on the model of Gamboa versus Teves, where after the court ruled on purely legal issues, it remanded the case. In the case of Gamboa versus Teves, it remanded the case to the Securities and Exchange Commission. Now, in your view, if a majority of the court is minded to remand the whole or part of this case to a body, which body should it be?
At the very least, Your Honor, it would have to be, I think, the City of Manila, because they're the ones on the ground. That is why in our proposal, we say it has to be the City of Manila by way of continuing mandamus, as in the Manila Bay case of Justice Velasco. Right? But if the court wants additional protection for to ensure the full enforcement of its judgment, it has the authority to include, say, the NCCA, because it has regulatory power when it comes to matters that are inimical to the implementation of heritage laws, or even the NHCP, which has the undisputed authority over this particular matter.
I believe, Mr. Soljan, your answer is premised on your assumption that the court will accept your argument for a total dismantling. My question really is, assume that the majority of the court want to have a trial of fact on what is the minimum height, 18, 7, or 8, and would want to remand it. My question is, to which body or court should it remand such a question?
If I may just clarify, Your Honor, our assumption is not that the Torre de Manila, if our arguments are accepted, should be entirely abolished. Our argument is simply that it should be abolished to the extent that it impairs the sightline of the Rizal monument. We're not saying that the DMCI has no authority to construct anything on its private property. We're simply saying that it has to comply with the city ordinance and with our national laws on heritage. If that means 7 floors, as we think it is, then it's simply a straightforward application of the formula that will be accepted by the court. But if the court says, for example, that, well, maybe up to 10 floors, it doesn't impair the sightline, then I suppose that might be a triable question of fact that the court might have to remand to a trial court. But we believe, Your Honor, that given the case that we have presented, the court, at the very least, must order the demolition of Torre de Manila, and the only question that should be left should be the extent to which it should be demolished.
No, that's still part of my question, Mr. Soljan. FAR is a matter of computation, but there are 3 different answers to how many stories or how many floors does FAR 4 translate. So I think that is a triable question of fact. The second triable question of fact, that now that you have brought it up, is under your theory of Section 25 being interpreted to mean a protection to the sightline, then there is a question of what is, apart from FAR, what is the appropriate sightline that is given as a protection to the Rizal Park and the Rizal Monument. Again, I suggest to you that from where we stand as we speak, and even probably as we hear NHCP, we would have no idea on what is the proper sight line? What is the proper height to protect, apart from an independent of FAR? So again, that's my question, Counsel. If for example, a majority of the court decides to remand it, isn't that the sight line appropriate to the Luneta Park or the Luneta Monument? Isn't that a triable question of fact?
Thank you, Your Honor. The court is not required in this case to determine the metes and bounds of the sightline of the Rizal Monument. What we're saying is that the court can take judicial notice of the fact that the sightline of the Rizal Monument has already been impaired, regardless of the metes and bounds of that sightline. The monument, Your Honor, is meant to be seen front-facing. That is how it is ought to be, how it is meant to be seen. And so the relevant sightline is when you're standing in front of the monument, as we have here in our slide, right? There is no doubt that any reasonable person will question whether or not the sightline has been impaired, regardless of the angle of vision of a particular person. I noticed during the presentation of DMCI that they have assumed that we're like horses, raced horses with a very narrow sightline. This is the regular viewing angle of a normal human being. When you stand in front of the Rizal Monument and you assume that it has a sightline, as we believe that it has, there can be no doubt that you will have to make the conclusion that the sightline has been impaired.
Mr. Soljan, using your photograph, and I think counsels can look at and see it. And
that is from the official Gazette, Your Honor, and so
yes,
that is
yes.
an official
so
publication.
So I guess this is from the center line, if you may.
Yes, Your Honor.
I point to you, there is a portion in the photograph, which is the building, the torre, which is almost colored white, and there is a portion which is almost colored blue. Is that right?
Yes, Your Honor.
Now, to me, isn't it a triable question of fact whether if the building is only up to color white, and I don't know how many floors is that, it is a triable question of fact of whether that height, and I don't know what it is sufficient protection for sightline, or is your position that any number of floors? That's why I thought your proposition is 8 floors is okay.
If we are to follow, Your Honor, the ordinance, 7 floors.
Because again, you will have to wait for a majority of this court
Yes,
to make its decision. And that's why I made very clear the position of the government. Section 15 of the Constitution is not self-implementing, right?
Yes, Your Honor.
You have to source it somewhere. You are sourcing it, as you admitted, on RA 166, Section 25, right?
Not just Section 25, all heritage laws, Your Honor,
Yes.
are in full implementation of the language of the Constitution. And if I may, Your Honor, so when, for example, in the statute of the NHCP, the law says conservation. It says it refers to all processes and measures of maintaining the cultural significance of a cultural property, including but not limited to the physical, social, legal preservation, restoration, reconstruction, protection, adaptation, or any combination thereof.
I
That
agree.
is a very broad articulation of the constitutional principle.
I agree with you, Mr. Soljan. So broad that a view can be taken that none of the laws you cited, including 166, mentions the word sightline. Now, I may accept that sightline as a principle under your physics argument. Sightline has to be protected. But then, as you say, what is the proper sightline given a certain set of facts, may, to a majority of this court, be a triable question of fact. That is on 166. That is my question. Quite apart from, again, as you admitted, Ordinance 8119 is another source of
Yes, Your Honor.
positive law, a city ordinance. It is an indirect limitation. It is an indirect protection to sightline. To the extent, that's why it's very important that we know what exactly is the translation of FAR 4, because then one can argue that that's the limit of the protection. And there are two different protections as you talk about layers. So in both, Mr. Solgen, I suggest there are triable questions of fact.
Ultimately, Your Honor, it will have to depend on the theory that will be adopted by the entire court in this particular case. If the theory that will be adopted by the court is that the City of Manila gravely abused its discretion in granting an exemption, then we're down to basically FAR 4 7 floors. And there's no question about the extent of the impairment. It's just a blanket statement on the part of the court that you cannot go beyond 7 floors when it comes to this particular area.
Thank you, Mr. Solgen. And that
Thank
brings
you.
me to my last question. The reason this court can invalidate the zoning permits will be on the ground that the permits were invalid. Essentially, grave abuse of discretion.
That's one way of going after it.
Now, that's one way, and that's why it was asked, and I ask you also, will you have jurisprudence where in an action for mandamus, the Supreme Court has allowed to make findings based on grave abuse?
We will look for the cases, Your Honor.
Please
We will
look
provide
and
them.
be very careful in your memorandum. My staff have found four cases where this court, in an action for mandamus, based on the facts that were unearthed during the litigation, the court, in at least 4 cases, mandamus cases, made findings of grave abuse. So that is very important, Mr. Solgen.
Thank you, Your Honor.
Thank you very much.
If I may just clarify, Your Honor, my final statement about the relief that ought to issue from the Honorable Court is, I think, rather straightforward. If a construction is declared illegal, as we believe it is, then the private respondent has the responsibility to remove that illegal construction. And by way of protecting the judgment of the Honorable Court and ensuring the enforcement of its decision, what we are simply proposing is that the court perform what it did with respect to the Manila Bay. It created a relief called continuing mandamus, and so if a continuing mandamus can be issued for the protection of heritage, the protection of our environment, then certainly a writ of continuing mandamus can also issue for the protection of our heritage. Thank you.
Thank you again, Mr.
Okay,
Solgen.
that's noted. Justice Leonen, and then Justice Leonen, and then Justice Bernabe.
Yield to Justice Bernabe.
Okay, Justice Bernabe.
All right, good afternoon.
Good afternoon,
Soldier.
Justice
Yes.
Bernabe.
You earlier stated that the sightline of the Rizal Monument is protected by Section 15, Article 14 of the 1987 Constitution. Is that correct?
Yes, Your Honor, through the appropriate heritage laws.
Yes, and this provision is not self-executing, and this is implemented by many laws, particularly Republic Act 166.
Yes, Your
That
Honor.
is correct. And you classify the protection of the Rizal Monument sightline as a protection of its physical integrity, basically because you gave it a broad meaning and a flexible attribute.
Yes, Your Honor. We believe that is a practical reading of the statute, given that, as per my example, the way to protect a painting is by controlling the temperature of its environment. In this particular case, the way to protect it is its physical integrity is by protecting its sightline.
Okay, now, by what judicial standard can the court determine if a structure derogates the sightline of a cultural property, other than what you said, that you're giving a broad meaning to physical integrity and the visual impairment of the sightline? Is there any other law that gives a specific standards for the court to follow?
I suppose, Your Honor, after the decision of the court in this case, our local governments and our national agencies will probably begin clarifying rules with respect to sightlines. And so we believe that the court is in a very unique position here to provide guidance to local governments and to the national agencies. But with respect to this particular case, we believe that given the physics of the Rizal monument, there can be no doubt that this monument, this particular monument, has a sightline. And that is a question of law that the court can simply answer.
Would the determination of whether a structure derogates the sightline a matter of policy beyond the court's power to decide or to determine?
Yes, Your Honor, as a general matter, local governments, the Congress can create broad rules with respect to the protection of sightlines of monuments in general. But with respect to particular monuments, I think, Your Honor, it's a question that can be resolved in specific cases by every court, as is the case in this particular instance.
Now, the Manila Zoning Ordinance number 8119 limits the use of land within the city of Manila by classifying areas into different zones and prescribing maximum percentage of land occupancy and floor area ratios. Would you say that these restrictions are somehow related to the preservation of historical sites and facilities?
Indirectly, Your Honor, yes. Because the zoning ordinance is a broad-based ordinance. It's a general policy with respect to height of buildings in the entire Manila. I think if they intend to protect specific heritage areas, they can carve out specific rules so that they can highlight the need to protect particular monuments, particular sites, particular buildings.
So going back to the sightline, how can the court draw a line between the protected aspects of a cultural property and those which are not protected?
Your Honor, as a general matter, the court can do that by reading into the statute the possibility that the physical integrity of a cultural artifact can theoretically include its sightline. In particular, with reference to this case, given our argument that the Rizal monument historically and was intended, has always been intended to have a sightline, the court can declare that the Rizal monument, in fact, has a sightline that should be protected.
But you will agree that there is no law that provides specific standards for the court to follow?
Your Honor, I think the court can take judicial notice of the fact that the Rizal monument, is a monument that has a sightline. Not all monuments have sightlines. There are monuments in rotundas, and therefore they were never intended to have a sightline. But with specific reference to Rizal monument, David Burnham intended it really to have a sightline because he was patterning it after the Washington Monument. And so, well, the irony is that whereas no one will question that the Washington Monument has a sightline, we are here in the Philippines fighting for the sightline of the Rizal Monument.
Okay. Thank you, Counsel.
Thank you, Justice Bernabe.
Thank you, Chief.
Justice Leonen.
Good afternoon, Counsel.
Good afternoon, Justice Leonen.
I am intrigued by your interpretation of the nature of enforceability of constitutional provisions. So let's start with that. So hopefully, I think our assistant can flash on the board on the screen section 14 of Article 14 of the Constitution. By the way, Counsel, what is the Constitution? Is this not the fundamental and basic law of the land?
It is, Your Honor.
Yes, and this Constitution is law in terms of all its provisions. Is that not correct?
Yes, Your
And
Honor.
if it is law, then it's a reality as law. Is that not correct?
I suppose, Your Honor.
And if we say self-executing and non-self-executing, it is in relation to an act. Is that not correct?
I suppose, Your Honor.
Yes, and therefore, it is not correct to say and to stop at executing and non-self-executing without stating what the prestation is. Is this not correct?
As a general matter, I suppose.
And therefore, that classification of executing and self-executing, in the cases that actually used it, principally, for instance, the Manila Prince Hotel, among others, was in a particular context. And that was for a particular prestation that was being prayed for in the petition. Is that not correct?
I think, Your Honor, if I may, the debate about self-executing, non-self-executing is,
Well, it's a debate now that is now an issue in this particular
Your Honor.
case. For example, if you look at Section 14, it starts with who the actor is. We'll do a bit of Hofeldian analysis here, if you do not mind, counsel. So we have here, the state shall foster the preservation. May I know who the active subject is supposed to be?
well, it depends on your theory of what the state
Section
is.
14 states that it is the state, correct?
Yes, Your
Yes,
Honor.
clearly in the provision, it says it is the state. And the state is not the Solicitor General, not this court, but it also includes Congress and the executive. Is this not correct?
Again, Your Honor, it depends on your theory of what the state is for purposes
Yes, but
of
it says here,
constitutional
the state
analysis.
shall foster the preservation. This is very textual. So it means that it is the entire state that shall preserve, enrich the dynamic evolution of Philippine national culture. Is that not correct?
Correct, Your Honor.
Okay. Now here it states, it sets a policy, and that policy is effective immediately. But it does not require a particular prestation except to foster. Is that not correct?
Correct, Your Honor.
The policy is that we should have a national culture, but that national culture is based in the principle of unity in diversity. In other words, there is no monolithic culture existing in this country per this provision. Is that not correct?
There's none in any country, actually.
Especially the Constitution, our Constitution says unity in diversity. Similar to that of Indonesia, Bhinneka Tunggal Ika. Is that not correct? So therefore, we recognize all cultures, but there is a contribution of all cultures within each society and community in this country to a Filipino national culture. Is that not correct? Yes. And therefore, it is the state that has the duty, and the state includes both Congress, this court, and everybody else. Is that not correct?
Correct, Your Honor.
Yes. And therefore, the state here means that it is not only the court that does an active, affirmative fostering of all of this, that it has to do it in conjunction with every other element of the state. Is that not correct?
Correct, Your Honor.
Yes. And you said that insofar as this is concerned, the state has acted through Congress by the laws that you have enumerated, with the broad provisions that you have enumerated, and you are now asking the court to find more in those particular laws.
No, Your Honor. We are saying, Your Honor, that the state has not exhausted the constitutional policy by acting through Congress. We are now asking the court.
But the court cannot create law. Is that not correct?
Again, it depends on your constitutional theory, Your
In
Honor.
other words, we are not a legislature. We only interpret the provision of law, no matter how specific or broad it is.
Yes, Your Honor.
Yes.
I
So
agree.
that is the judicial action that we can take insofar as this case is concerned. So Section 14 states a broad policy, which means that if there is a law which prohibits a monolithic culture and imposes it on all peoples in this country, for example, the Manobos, the Bagobos, then it will be unconstitutional. But if it
depends on
fosters the
facts.
diversity of a culture, then that law will pass the tests for, let us say, police power, etc.
I suppose, Your Honor.
Okay. Now, Section 14 is not the section that is involved in this case. More specifically, you have Section 15, correct?
Correct, Your
And
Honor.
Section 15 actually states the following. Can we go to Section 15? There are two sentences in Section 15. Arts and letters shall enjoy the patronage of the state. That's not relevant for this case. Is this not correct?
Correct, Your Honor.
It is the second sentence. Again, the active subject is the state shall conserve, promote, and popularize the nation's historical and cultural heritage and resources. Is that not correct?
Correct, Your Honor.
Okay, redendo singula singulis. So you have two nouns, heritage and resources. Is that not correct?
Correct.
And for each of them, it is qualified by historical and cultural. So you have historical and cultural heritages and historical and cultural resources, correct?
Correct, Your Honor.
Okay, now the Rizal Monument, well, you also have as well as artistic creations, just to be precise, correct?
Correct, Your
Okay,
Honor.
which noun applies to the national monument? Is it heritage, is it a resource, or is it an artistic creation?
It's a heritage, Your Honor. Cultural heritage.
Cultural or historical heritage?
Can be both.
Can be both. Okay, we focus now on historical and cultural heritage, and the state action, the prestation required of the state is to conserve, promote, and popularize. Insofar as the state as an entity is concerned, this provision is executing, correct? Except that its mandate is broad. Therefore, you cannot say that it is non-self-executing.
Again, Your Honor, it depends on your constitutional theory.
Okay, then let's go to section 16. And this says that all the country's artistic and historic wealth constitutes the cultural treasure of the nation and shall be under the protection of the state, which may regulate its disposition. So here, this is with respect to the disposition of an asset, correct?
Not necessarily, Your Honor.
What else does it cover?
It covers everything, but it has a specific sentence with respect to disposition.
Yes, it says under the protection of the state, which may regulate its disposition. So the protection can be not only the regulation of its disposition, but other things.
All forms of protection.
And this is effective immediately, except it's a broad statement. Is that not correct?
Correct, Your Honor.
Yes. Now, we go back to your photo of the Rizal Monument. Not the one with the president laying a wreath, but the one without anything in the background. Can you please
The real Rizal
help us to show that photo? Of course, it's already imprinted in our minds. Would you know if Rizal, when he died or prior to his death, left any will or any desire with respect to how he wanted to be buried?
No, Your Honor.
In the Philippine Daily Inquirer this Sunday, Ambeth Ocampo, who is a historian, said that in his pockets were found several notes, some of which contained his instructions. And the instructions were he wanted to be buried in an unmarked grave with no frills. Would you agree to that?
Well, I cannot agree or disagree because I haven't seen the will.
And may I ask that you cover, because you said that this is a historical heritage, that you cover what is historical about the monument, starting with the desire of Rizal in terms of how he wanted to be buried.
Your Honor, if I may, I will have to object because
You cannot object because I'm requiring you to actually put in your memo the position of the Solicitor General with respect to what was the actual wishes of Rizal. Only that. And with respect
I will try,
to,
Your Honor.
Yes, and with respect to how it relates to that big monument.
no relation whatsoever.
No
Your Honor.
relation. In other words, Rizal did not say that he wanted or disliked that monument.
He never lived to see the monument, Your Honor.
He never instructed anybody to construct that monument.
I think, Your Honor, this case is not about whether Rizal wanted anything.
Historical heritage. So
Your
my
Honor,
question is, and I hope you can give me a very clear response, because then you can have the entire memorandum to put your own opinion. But what I'm asking is a bit factual. Did Rizal want that kind of a monument to be crafted by a Swiss artist?
we will try, Your Honor.
Did Rizal want that kind of monument to be constructed by a Swiss artist? I hope
We
you
will
are not
try.
evasive, Mr. Sojan, because this
I'm-
was constructed by a Swiss artist, correct?
Yes,
Was he
Your
in
Honor.
communication with Rizal?
He was already dead.
He
by
was
the time,
already
Your
dead. Therefore, did Rizal instruct that this monument be this way?
Honor. I suppose he didn't.
Because your premise for your entire physics argument is that this is the status quo. This is the historical artifact. This is the historical resource. And I want you to cover that. Why is that the premise? Can you do that in your
We
memorandum?
will, Your Honor.
Thank you. Physics of the monument. Are you referring to physics as a science or part of your eloquence?
Your Honor, in
Because
fact, if you look
physics
at
will
science,
include the atoms. Are you using Newtonian or Einsteinian physics?
depends again on the
Or are you
level of
using the
generality.
physics of light here? Or is it physics in terms of carrying an argument from the temperature with respect to a canvas and then jumping off by an intellectual move and passing it off as an argument for the monument?
We are referring, Your Honor, to the physics of the Rizal Monument as
Can you
a
demonstrate
physical
in your
artifact.
memoranda how physics as a science would apply to this, analogous to your statement about the Sistine Chapel and all of
Yes,
that?
Your Honor,
Because you
definitely.
introduced it. Okay. Next, the Republic is who you represent, correct?
Yes, Your
Yes, and you are a tribune of the people, is that not correct?
Honor. Yes, Your Honor.
And by the people, we mean all the peoples, because there are various communities in this country, is that not correct?
Correct, Your Honor.
Take a look now at the table of the respondents. Seated there are councils for DMCI and the City of Manila. Are they people?
I think they are, Your Honor.
Can we take judicial notice that they are people?
Yes, of course.
Now, take a look at the mammals at the back of that bench. Would you say that they are people too?
Yes.
So by people, what do you mean?
I refer to people as a collective,
As a collective.
not to individual
Okay.
lawyers.
Who expressed their voice to you through who?
That's not necessary, Your Honor. It's the Congress that has empowered the Office of the
No, I
Solicitor
mean,
General.
for your position here, you said that you are counsel for the Republic, which is motivated by the people, powered by the people, and you are a tribune of the people. I am just curious how you arrived at your two interpretations. One was the comment, and which you abandoned, of course, and the other one is the position paper, which is now pending. My curiosity is, which people actually told you that this was their position? You are counsel, correct? Of the people.
Yes, Your
Yes,
Honor.
and by counsel it means an agent, correct? And that's what counsels are. There is a principal, correct?
Yes, Your
Yes,
Honor.
and therefore, who are the people who are your principals?
The Republic, Your Honor. Every public officer who is entrusted with discretion represents the people in some way. Under the revised administrative code, Your
For
Honor,
example,
the Office of the
officially,
Solicitor General.
there was the National Historical Commission of the Philippines created by law. And the representatives there was appointed by law, by the authorized appointing power. And you say now that they are not the people that you represent, correct?
I'm not saying that, Your Honor.
Your
I'm saying that
manifestation
they-
said that you have ceased to be their representative. But
Yes,
you
but
are a
those are two
representative.
separate statements,
You are a
Your Honor.
representative of the other agencies, correct?
Yes, Your Honor.
Yes. And again, can you include that in your memoranda?
I will, Your Honor.
Yes.
Thank you.
Which part of the people are you representing? Because counsel, you are supposed to help us protect the Constitution. Is that not correct?
Yes, Your Honor.
And I hope that you will contain a balance in your Constitution with respect to the constitutional provisions that we just put on the screen, as well as the due process clause for the rights to property, which definitely the respondents also have. Is that possible, counsel?
We believe, Your Honor, that our position is already balanced.
Okay, but in your memoranda, we hope that you can cover why the property rights of the respondents can be affected by both the substantive interpretation that you have offered and the reliefs that you have requested this court to grant.
We will do that, Your Honor.
Okay. By the way, for people, do you confirm that you did a Facebook post
Yes,
explaining
yes, Your
to the
Honor.
public why you changed your position?
Yes, Your Honor.
And you said that there were two persons that made you change your position.
I think they're probably here.
Yes, but you said that there were two persons, correct?
Yes, Your Honor.
And this is Lucille, and
My classmate, Your
your
Honor.
classmate, and the other one is Albert Muyon.
My professor.
Yes, your professor. How many people are there in the Republic of the Philippines?
I think about 100 million.
Yes,
Your Honor.
100 million. And these two individuals represented how many?
I don't think you need to consult with 100 million people
But
to
you are
come
the
up with a
Solicitor
position.
General, you're a public official, and you have to explain to your public why you focused on the opinion of your classmate and that of Albert Muyot. As a matter of fact, Mr. Solgen, do you routinely defend what you do as a Solicitor General, as a confidential attorney of the Republic through Facebook?
I think, Your Honor, it's important to realize that every person who has been entrusted with discretion can exercise it in representation of the people. Members of the Honorable Court, all other public officers, in fact, represent the people at some level or
And in
or
a
another.
particular way, we are accountable to them, such as, for instance, in our case, in terms of our written decisions. Did you or did you not post this statement? Let us hope the Supreme Court is prepared to defend a national cultural treasure publicly.
Yes, of course, Your Honor.
And you did that to generate support and mobilize it for your side.
Well, I suppose, Your Honor, that is a
Is that
statement.
allowable for counsel for the Republic?
I think, Your Honor, this is a public interest case. In fact, all cases handled by the Solicitor General are public cases. This is not a private matter. The level of interest of everyone in every public interest case, Your Honor, transcends the normal boundaries of litigation.
I have to ask that because it's in part of the manifestation of the NHCP.
Yes,
and I
Your
wanted you to clarify what your position was and whether it is part of the role of the Solgen to do Facebook posts or whether it is more, shall we say, prudent that cases are not discussed in that kind of social media.
Again, Your Honor, the case is a matter of public importance. I could have gone on TV, Your Honor, and presented my theory on this particular matter. I decided to reserve my opinion, with my limited friends.
I don't think you only have limited friends, Mr. Solgen. I know you have lots of friends. But that nonetheless, I just wanted to clarify what that move was for. Okay, during your presentation, you said that there was a precautionary principle. Is that not correct?
By analogy, Your Honor.
No. Precautionary principle exists as a legal doctrine.
Yes, Your Honor.
Okay. Can you tell us where we can locate the precautionary principle?
I think it's in the rules of the Supreme Court already when it comes to environmental cases.
For purposes of procedure. But where is the substantive basis for precautionary principle?
It's in the power of the Honorable Court to create rules.
Really?
Yes.
I mean precautionary principle as a substantive norm rather than a procedural rule.
I think, Your Honor, the court in creating procedural norms
Because if
directly
you're
and
going
indirectly
to-
creates substantive norms.
Because if you are going to make that move, that there is an analogy between some new principle now in cultural preservation and precautionary principle, perhaps you should lay down the genealogy, such as, for instance, where the precautionary principle comes from and why it is legitimate to do an analogy with respect to conservation of culture. If you want this court to come out with a prominent landmark, perhaps you can cover that also in your memoranda and draw for us that genealogy. Can you do that,
We can do
Counsel?
that, Your Honor.
Yes. Judicial notice, and you're asking the court to take judicial notice of the view. Is that correct?
Yes, Your Honor.
Yes. Now, you do photography, I assume, correct?
I used to, Your
You
Honor.
used to do photography. Would you know what a focal length is?
Yes, Your Honor.
Yes, focal length is the distance that the light can travel from the lens to a converging point inside the camera. Is that not correct?
Correct, Your Honor.
The lower the number, such as a 15 mm lens, will be wide angle. Is that not correct?
Correct, Your Honor.
Which is, of course, the favorite lens of the respondent, correct?
I
Wide
don't-
angle puts everything on the background smaller than how it is. Therefore, when you take a shot with a wide angle lens, therefore what you see would be what, as prominent would be what is near you rather than what is far. Is that not correct?
Correct, Your Honor.
Yes. And a focal lens with a high number, such as a 200 millimeter lens, would therefore flatten the depth of field and therefore put the building right smack at the back of the monument. Is that correct?
It's possible.
Yes. What is the normal vision of the human eye?
I
What
think
is
it's
the focal
35
length?
millimeters.
35 millimeters.
Well, depending on the camera that you're using, whether or not it's a full frame or a limited frame.
Yes. And line of sight, therefore, would mean using 35 millimeters, or does it mean also the use of any kind of camera because what has been made popular in the public now is the concept of a photo bomber, correct?
Correct, Your
As a
Honor.
matter of fact, the objections to the Torre de Manila was any kind of a camera with the building behind it. Is that not correct?
I think, Your Honor, that's one of the objections, but the objections mainly come from those who actually go there and see how
Because you made the statement
physical
that
integrity
we
is
should
impaired.
take for judicial notice the fact that it already ruins the sightline.
it impairs the sideline.
Yes,
Your
that
Honor.
was your statement.
Yes, Your Honor.
And that is unquestionable demonstration,
That is capable of unquestionable demonstration.
regardless of the focal length of the camera.
Well, I'm referring to the human eye, Your Honor.
Human eye. But
Yes.
again, I thought that part of the objection to the Torre de Manila was not only what the eye can see, but what the eye can memorialize through the process of photography.
I didn't make that argument, Your Honor.
In any case, that would be part of the petition right now, correct?
I
In
don't
fact,
know
it
whether
makes
it
that
was part.
allegation.
I don't know, Your Honor, if the petitioner made any references to
But you would say
photography in
that
their
we should take
petition.
judicial notice of the line of sight that it's already impaired.
Of a human being, Your Honor.
Yes, okay. If it is illegal, regardless of the remedy, the court has to do something, correct? That was
Well-
your point with respect to the remedy. If something is clearly illegal, then the court must give a remedy so that that illegality can be addressed. Is that correct?
No, Your Honor. The court is not a roving commission looking for,
Okay.
signs of illegality and everything.
So in what context did you use the term illegal? If the building is illegal, please continue my statement.
If the building is illegal because it violates the ordinance and the laws, and therefore, given its illegality, it has to be demolished.
Shouldn't the proper court for a proper case for demolition be filed with the proper court?
This is a proper court, Your
A
Honor.
proper court filed, and you filed here an action for, or you support the petitioner in an action for mandamus, correct?
Yes, Your Honor.
Yes. What is the clear, non-discretionary ministerial duty of the respondent in this case?
To oversee, by way of continuing mandamus, the demolition of Torre de Manila, an illegal construction.
Is that what continuing mandamus consists of?
I suppose, Your Honor, that
And
can be
continuing
done.
mandamus is applicable for environmental cases, correct?
Yes.
Yes, this case is environmental.
Your Honor, that's why we're asking for an application by
So
analogy.
you're asking
It
us
is
to
a
create a
logical
rule.
device.
You're asking us to create a new rule and apply it prospectively to apply to DMCI specifically.
That is what the court did in the Manila Bay case.
You're
Your Honor.
asking the court to do that again.
Yes, Your Honor.
Yes, and you're asking us to create, therefore, this new rule. By the way, in the MMDA case, since you are the Solicitor General and your office is actively a participant thereof, after the issuance of the writ of continuing mandamus, what positive action has the court done with respect to all the quarterly reports that have been submitted by government agencies?
I'm not aware, Your Honor.
None. In other words, this court has accepted all the compliances, but in my view, because of the lack of standards, it has kept all the compliances coming in without looking at whether the Manila Bay was actually clean. So you want a continuing mandamus also for this purpose, is that correct?
If the court has not acted on the reports in the MMDA case, Your Honor, then certainly the court has the power to do something about it.
Do you have basis to say that the city of Manila cannot act to pass an ordinance?
In fact, it can, Your Honor.
It can. And it can pass an ordinance to actually protect the sightline, correct?
Yes, Your Honor, they
Yes.
can do that.
Do you have evidence to show, or will you argue, that Congress cannot pass a law to protect the sightline?
It has already passed a law, Your
Specifically, this sightline?
Honor. No, of course not.
No, none. So Congress is open, correct?
Yes.
Would you know if there are any bills that are pending with respect to this controversy?
Maybe an amendment, Your Honor, of the cultural agency's laws.
What bill is that?
I am aware, Your Honor, of the fact that a bill has been filed or is about to be filed amending the charter of the NCCA.
So therefore, there is already a pending action of Congress. on this controversy?
Not with respect to this particular controversy, Your Honor.
Not with respect to this particular I thought
A
that there
statute,
were...
Your Honor, applies as a general matter to all,
No, my question
of its
was, is
subject.
there a bill or is there an action of the Senate or the House of Representatives in relation to this controversy?
With respect to the Senate, Your Honor, a Senate investigation conducted by Senator Pia Cayetano.
Okay, and you want us to issue a relief even before the Senate can act?
Well, certainly, Your Honor, because the case is already here.
In other words, we should not wait for the people through their representatives to actually act. And that you are asking this court now to act on the basis of your proposed interpretation of very broad provisions in all the statutes, because they do not say Rizal Monument. They do not say National Monument of Rizal, correct?
A statute, Your Honor, is meant to apply generally.
Okay. The statute was meant to apply generally, yes, but insofar as this sightline is concerned, does it mention the word sightline,
No, Your Honor.
visual corridor?
No, Your Honor.
Yes, and therefore, you're asking the court now to put words into the
Not at all.
statute.
Not at all, Your Honor. We're asking the court to choose between two interpretations. One that is restrictive, one that is broad enough to cover the sightline of certain monuments, and in particular the Rizal Monument. Why? Because that is the way to interpret the Constitution and the statute.
What was the initial petition that was filed?
Petition for injunction?
Injunction. Does this court have jurisdiction over a petition for injunction?
None.
None. Did anyone file a motion to convert the action from a petition for injunction to mandamus?
I'm not aware of anyone filing a
You are
petition
counsel
to
in this
convert.
case. Is there a motion that was filed by the petitioner?
There was none, Your Honor. The
None.
court did it on its own.
Can this be done by the court?
The court can do it in certain cases. As a general matter, the court does
rather
not do
than
it.
dismiss it on the basis of what the petitioner filed, because we assume that the petition knows all the possible causes of action, we, the court, therefore change the petition to the prejudice of the respondent. Can this court do that?
It didn't prejudice the respondent, Your Honor. The court has the authority, as it has done in cases that it has
It
deemed
did not
important.
prejudice the respondent. And you are speaking for the respondent or for the Solicitor General?
Respondent, the government, Your Honor.
For the government.
There's a respondent, DMCI. It didn't
Did it
did not
prejudice
prejudice
DMCI?
DMCI. I
Did
don't
it-
think so, Your Honor.
You don't think so. And perhaps it can also be covered in your
We will cover it, Your
memoranda.
Honor.
Okay, finally, my question. In a petition for mandamus, can we do the relief that is being prayed for in the petition?
Yes, Your Honor,
Why?
which is to demolish Torre de Manila.
Demolished by who will demolish?
The one who constructed it illegally.
So a writ of mandamus will issue because it's a legal duty on their part to demolish, because
No, Your Honor, the demolition will arise as a consequence of the declaration that the construction was illegal. No writ. It's just a writ of enforcement coming
so you
from a
want this
judgment.
court to declare it as illegal on the basis of evidence that was presented when?
No evidence is required, Your Honor. A legal interpretation that the
Counsel,
Torre
you
de
mean
Manila
that there is no
impairs-
evidence required to make a finding from this court that what DMCI did was illegal? It
all
just
the
needs a
documents
legal
are here.
interpretation.
Your Honor, in
example-
certain cases, the court has required the Solicitor General to present documents. In the DAP case, in the PDAF case, it has never stopped the court from requiring, when it wants to, certain documents and evidences from the government.
But the DAP case was not a writ of mandamus. It was
It
not a
doesn't
petition
matter,
for
Your Honor.
mandamus. It
The
matters,
general
counsel.
point is that in certain
By the
cases...
way, counsel, therefore, for instance, the date of the zoning ordinance, the date of the clearance that was issued by the planning officer, that it was actually issued by a certain Resti Rebong. Should we accept a testimony from Resti Rebong here, or should we, by judicial notice, actually say that it was he that issued it?
Your Honor, those documents are undisputed. They are the documents presented by private respondent in the City of Manila, by
But
the
I hope
parties.
that you will be clear in your memoranda, counsel, as to how this can be declared as illegal at this stage with this kind of a remedy. Can you do that in your memoranda, counsel?
We will do that.
Just to shorten my period for questioning, because a lot of us would want to ask you a few more questions. Thank you, Counsel.
Thank you, Justice Leonen.
Justice Carpio.
Counsel, when you submitted your comment, you were representing the National Historical Commission, correct?
Yes, Your Honor.
And you agreed with the Historical Commission that the Torre does not violate any law or regulation, does not mar the sightline, and physical integrity does not include sightline, correct?
Correct, Your Honor.
So now you turn around and adopt a different position, contrary to the position of the National Historical Commission, correct?
Correct, Your Honor.
Can a lawyer represent a conflicting interest against a client in the same case? I mean, you turned around in the same case, now you are arguing against your own client in the same case.
Your Honor, again, the Solicitor General's immediate clients are the agencies.
Are you saying that,
under the Administrative Code?
are
if
you
I may
saying
continue.
that the Solicitor General is not bound by the rule on legal ethics?
He is, in fact, bound, Your Honor.
So now a lawyer cannot represent conflicting interests in the same case, correct?
Correct, Your Honor.
But you are not bound by that. That's what you're saying.
I
Because
am.
you are a tribune of the people.
In fact, Your Honor, I am bound by that. That is why I have manifested that I cannot anymore represent the NHCP.
But yes, but a lawyer who turns around and adopts the position of the other side cannot continue in that case, correct?
As a general matter for private counsel, yes.
But now you are carving out an exception. That as far as the Solicitor General is concerned, you can do that with respect to your client agencies of the government.
In fact, Your Honor, we do that as a matter of course. In expropriation cases, we file notices of appeal, and then we withdraw it. In nullity cases, we do it as a matter of course. I can provide you, Your Honor, with at least 100 exceptions, 100 instances we have decided to change our position because we believe that the interests of the Republic and the general welfare will be promoted. We do that as a matter of course, Your Honor.
Okay,
And
you
you
give
should
me
be
a
aware
list of
that.
those cases where you took the other side against your former client.
We will, Your Honor. Top of my head, Your Honor, the PCGG cases handled by former Solicitor General Chavez would be the highlight examples, at least in the culture of the OSG, of those kinds of instances.
Okay. You also represented the NCCA in this case when you filed your comment, correct?
We still represent them as well as the National
Okay, you
Monument.
still represent them, but the position of the NCCA is that they have the power to issue CDO, correct?
Yes, Your Honor.
And your position is they don't have the power to issue CDO.
Yes, Your Honor.
How
which
can
is
you
why,
represent the NCCA?
We have agreed, Your Honor, that with respect to that particular question, they will file their own memorandum. But with respect to the general theory of the case as well as the reliefs that ought to be issued, the NCCA as well as the National Museum are with the government in this case.
So how can your client now confide to you, NCCA, when they know that your position is against their position?
Well, I suppose, Your Honor, they're still with me, and therefore they are still confiding.
So that's
in
allowed
the
under the
government.
rule on legal ethics?
I think that's not prohibited, Your Honor. I
That's
think
allowed? A lawyer can do that?
the point, Your Honor, is that the Solicitor General, as counsel for the government,
But there are other
has the
lawyers for
government
the
for his
government.
counsel.
You have the OGCC. Can't you not tell them, go get the OGCC?
The OGCC's jurisdiction is rather limited.
Yeah,
Your
but they can be, because there's, you have taken a position adverse to their position.
In
How
fact,
can
Your
you
Honor,
represent
under the
them?
Administrative Code, the Solicitor General can intervene in any case where he's not even a party.
Yes,
That is
not,
clear
but
under the Administrative
Does
Code.
the administrative code say that you can represent conflicting interests?
We no longer represent, we do not represent conflicting interests because we have manifested that the NHCP will be represented.
No, you say now that you are still representing NCCA,
Yes, Your Honor.
but you have a different position from NCCA on the power to issue
With
CDO.
respect to that particular power, Your Honor.
So you represent conflicting interests with respect to that power, correct?
That particular question, Your Honor.
Yes, with that particular question.
And that is okay, Your Honor, because that is allowed by the Administrative Code. The
Where?
power of the Solicitor General,
What provision in the administrative code?
the power of the Solicitor General is based on the assumption that his ultimate client is the government itself.
Yes, but
the
what
Republic.
provision in the administrative code allows you to represent conflicting interests in the same case?
Your Honor, that's begging the question. There's no conflict
But
of
you said
interest here.
according to the administrative code. Where is that provision in the administrative code?
There is none, Your Honor.
There's
It's
none.
part of the rules of agency of
Okay, there
the
is
power
none.
of the Solicitor General.
So, bottom line, you are not bound by the rules on legal ethics when it comes to conflicting interests.
Your Honor, I am not saying that. Your
Oh,
Honor.
you're not saying that now.
I'm not saying that, Your Honor.
So you're still bound.
Of course, Your Honor. All lawyers are bound by the rules on professional
Okay,
ethics.
so we will now decide whether you are now representing conflicting interests because you admit you are bound by the rules on legal ethics.
Well, I am a lawyer and officer of the court. That is part of the duty of the court to determine the sufficiency of representation of a
Because,
particular...
counsel, it's very strange. You are representing the NCCA, yet you're taking a position adverse to the position of the NCCA.
only with respect to a
Yes,
particular
even if it's
question.
only one, it's strange.
Well, this is a strange case in the first place, Your
Why
Honor,
is
and the
it
court
strange?
is not immune to handling strange cases. The court has handled
Why
many
is this
strange
case
cases.
strange?
Because, Your Honor, the Solicitor General represents not just one client. In
But
certain
you've
cases,
always done that.
he represents 3 clients who have conflicting views of their jurisdiction. I wish, Your Honor, that the Solicitor General can simply say, I want to represent the government and not represent any particular agency.
But you can do that because they can get their own counsel, like the National Historical Commission. Why
Yes.
don't you tell that to NCCA?
I
Let
think,
them
Your Honor,
get another-
it is the prerogative of the NCCA and the National Museum to retain the Solicitor General as counsel if they believe that the Solicitor General's position will promote the interests that they want to pursue. It's not for the Honorable Court to declare or disqualify the Solicitor General in a particular case.
Okay, is the NCCA represented here? NCCA? There's nobody from NCCA? Okay, Attorney Muyot, are you representing the NCCA here?
Well, I'm representing DepEd, Your Honor, as a ex officio member of the NCCA.
Okay.
But I am not I'm not organic to the NCCA, Your Honor.
Okay, can you tell us, not now, but you submit a manifestation, you ask the NCCA whether they want to be represented by another council, because there is now a conflict of interest between the NCCA position on the power to issue studio. There's a conflict of interest with the position of the OSG. Okay?
But I will advise the board, Your Honor, and await the decision of the board.
Okay, thank you.
Thank you, Your Honors.
Okay, Solgen, let's resume. You're saying that the words physical integrity in the law includes sightline, protection of sightline.
As a general matter, Your Honor, it can include sightline. I'm
No,
not saying
no,
in all cases.
Your position before was it did not include. Now you're saying it includes sightline.
If
Is
I
that
may,
correct?
Your Honor, so I can explain in full the reason why we
Yeah,
changed our
okay.
position.
Before,
so that the
when
court
you
can
first
be fully
submitted
informed.
your comment, you said physical integrity did not include sightline. Now you're saying it includes sightline. Okay.
If I may be allowed to explain why we did
Okay.
that, Your Honor. Okay, thank you, Your Honor. We handle a lot of cases, Your Honor, and your initial reaction, your initial reading of a particular case, Your Honor, our reading was that physical integrity should be equated with physical structure, which is the position of respondent DMCI. But when the court, after several months, issued a TRO and scheduled oral arguments, it gave us an opportunity to look again at the case, which meant that, allowed us to realize that we overlooked the fact that there's an underlying discipline of heritage conservation. And in that discipline, the protection of sightline is in fact an integral element of the notion of conservation. And so I had a choice between sticking to a position that was unduly narrow in my view and will not promote the Constitution's grand policies as implemented by the statute, or to be honest and attempt to be credible and present before the court what I believe to be the correct position on the matter, a position that will promote the national interest. We hope, Your Honor, that we get cases spot on. You know, we understand the full import of the meaning of the statutes that we read, but that is just hope, Your Honor. And so I am also comforted by the fact that the court in certain cases has found it prudent to reconsider its decisions, such as in the PDAF case, where the court overturned basically 2 decades of decision to come up with a new decision, which is progressive and anti-corruption in both tone and spirit.
Yeah, counsel, in the PDAF case, the facts were different.
But the principle is the same. We can argue,
No,
Your
we
Honor, about the
overturned
differences
because the
between
facts were different in the latest case. The facts in the previous cases were not there. In
I
the
think, Your
present
Honor, at
cases,
some point, we need to just tell people that we're reconsidering our judgment. You know, just in.
but did
like
the
in
facts
DAP
change
case.
here, counsel? Between the time you filed your comment and the time you changed your position, did the facts change?
In the DAP case, Your Honor, where the court reconsidered, and thankfully so, its decision, the facts didn't change, but the interpretation of the court
No, the facts
did
changed because there was reports already of the PDAF of the
I'm referring, Your Honor, to the DAP case.
You said mention the PDAF. Now you're saying the DAP.
That is an
Different.
example.
The
That is
DAP
an
is
example
different from the
where the
PDAF.
DAP case, you know, there was no change in facts.
The DAP
court
is a
ruled-
new creation. It was not there before in the bills, in the GAAs. We're talking of the PDAF. We
if
did
I
not
may
have
explain-
a DAP case before that we decided.
If I may explain, Your Honor, in the DAP case, the original decision of the Honorable
Okay,
Court
let's,
was to declare it
okay.
unconstitutional.
Counsel, let's go to the next point.
Okay.
You're saying now that the physical integrity includes sightline, okay? Does that include the frontal sightline?
Your Honor, when we refer to sightline, it's just the sightline, which is the line of sight of someone standing in front of the Rizal Monument.
So it's only the frontal sightline. If from where you stand and the monument, there should be no obstruction. That's the sightline.
Yes, Your Honor, that is the
So-
relevant sightline.
Where is Torre? Is it between you and the monument or at the back of the monument?
It impairs the sightline, Your Honor. It's
But you just said now that the sightline is between where you stand and the monument. That's a sightline.
the sightline, Your Honor, is what you see when you stand in front of the monument. And so when you stand
So
in
it
front of the
includes-
monument, it's as if you're looking at a painting.
Yes, when you look at the painting, you don't see anything behind.
Because
There's
the
only a
sightline,
frontal
Your Honor,
sightline.
the sightline,
When you
Your
look
Honor,
at the
is
painting,
over-
counsel, on the wall, you don't see what's behind the wall. So the frontal sightline is what is protected.
Depends
What-
on the painting,
My
Your
question
Honor.
to you is, are you saying physical integrity protects only the frontal sightline, the sightline between the person looking at the monument and the monument itself? That's the sightline you want to protect?
That is the sightline with respect to the Rizal Monument, because the monument was meant to be viewed front-facing. I'm sure there are a lot of people, you
How
know, there's-
far from where you stand to the monument is protected?
Again, Your Honor, what we're saying is that there is no need for the court to determine the metes and bounds of that sightline. But when you stand in front of that sightline, you can...
What if now the Rizal Park will construct a tall building across the street of the Rizal Monument? Does that mar the sightline?
Again, Your Honor,
Because there is Ross Boulevard.
yes, Your Honor.
Now, if the Rizal Park management will put up a building on the other side of the street, is that a violation of the sightline?
Well, Your Honor, certainly not, because it doesn't impair the sightline of the Rizal Monument, which is front-facing.
So when you say sightline, when you are standing just
In front of the Rizal Monument.
in front, how far in front?
Your Honor, the ordinary person looking at the Rizal Monument would stand in front of it. I think the physics of the monument itself allows you a certain leeway where you can stand in front of the monument.
How far? Because you are now saying it is protected by law, but the law has to be specific. How far?
The law, Your Honor, doesn't say.
Yes,
and
there
it
are no
cannot, in fact,
standards.
say.
The law, when it says physical integrity, you're saying physical integrity includes sight lines. But there are no standards how far the sight line should be, correct?
In this particular case, Your Honor, given the Rizal Monument's properties, you have to stand in front of the Rizal Monument, and when you stand in front of the Rizal Monument, there can be no doubt that your view is marred
How
and
far
impaired.
is, okay, 10 kilometers behind the Rizal
I don't
Monument?
think you can do that because that's already the sea, Your Honor.
No, behind the monument. Because
Again-
when you're standing in front of Rizal, you're facing east, okay? You're facing east. And now you see the Torre. That is about 900 meters. What if the Torre were moved back
Then
2
again-
kilometers behind?
I don't know, Your Honor, because
So
I
there
had
are
to
no
see for myself.
standards.
Your Honor, we are facing a particular
My
case.
question is, Counsel, if the Torre were erected 2 kilometers from the monument, would that be a violation of the sightline?
There's no need to speculate, Your Honor. We're facing
No, but
a
we have
specific
to
impairment.
When you say that physical integrity includes sightline, you are not saying how far. You have to state for the sake of the community, the developers.
Yes,
How they have to be guided that they cannot build 1 kilometer from the monument.
The
How
sightline-
far, Counsel?
It's not a question of how far it is. It's a question of what you can see when you stand in front of the monument.
So if
And
you
so
put
the
it there
court-
about 3 kilometers away, you can still see Torre. So that is a violation. Is that what you're saying?
I don't know whether
do
the
not
sightline
know.
will be impaired at that length.
You
at
do
that-
not know.
how far, but the court is required and being requested to decide a particular case.
So you are asking us to say it's a violation to put up a Torre behind the monument, but we don't know how far. That's what you're saying. That should be the ruling of this court.
The ruling of the court should be, Your Honor, that with respect to the Torre, it impairs the physical integrity of the Rizal Monument. The court is not being
you
required
want
to
us to come out
legislate.
with a ruling that will be specific only for Torre and will not guide all other developers so they don't know how far is the sightline protected.
I think, Your Honor, as was the proposal of Justice Francis Ardelesa, the actual metes and bounds can be determined in a trial of fact. But
But can the
regardless
court
of the metes and
determine the
bounds,
actual meets and bounds? Does the court have the power to determine how far the sightline should be?
Your Honor, I'm simply acting on the proposal of a justice
Yes,
of the
but you're
Supreme Court.
adopting it as your answer now. I'm asking you.
What I'm simply
You're not
saying,
adopting it.
that is a proposal that the court itself can
My
consider.
question then
I'm not a
is,
member
how
of the
far
court.
is the sightline protected?
There is no need, Your Honor, to determine.
No need to determine.
The only question here, Your Honor, is
Okay,
whether or not
counsel.
the sightline is already
So you are
impaired.
saying that what is protected is not only the frontal view, but the background sightline.
We cannot separate the frontal view from the back view of
Okay, how
the
about the
monument.
side?
Yeah.
The side. If you look at the monument from the side, you see these tall buildings along Ermita Street. Is that protected sightline?
No, Your Honor, because again, the Rizal Monument was meant to be seen when you're standing in front of the monument, when you're looking at Rizal looking
Okay.
at you.
Okay,
In
so
fact,
you're
the
saying
physics of
that
the
the
entire Rizal
sightline,
Park, Your
the
Honor,
sightline protects only the visual corridor where when you are standing in front of the
when
monument
a human being who's trying to appreciate the Rizal Monument is standing in front of the
with
Rizal
the naked
Monument.
eye, not with a
Yes.
telephoto lens,
Definitely, Your Honor.
with the naked eye.
Yes, Your Honor.
But you do not know how far. How far
There's
can
no-
the naked eye see?
There is no need. Again, Your Honor, you're asking me to answer a question that need not be answered in this particular
But
proceeding.
we will come out with a ruling that will have to guide the people, the developers.
I think, Your
You're
Honor,
asking us to legislate the sightline, but you don't want us to tell how far.
I'm not asking the court to legislate the sightline.
But
I'm
is
asking
the
the court.
sightline included in the law?
Yes, Your Honor, that is the
Is
clear
there an
answer.
express word sightline in the law?
It need not be expressed just like capital.
No, my
can
question
include
is
preferred
there an
shares.
express word sightline in the law, or any law for that matter?
I think, Your Honor, the answer is clear. There's none.
It's none. Thank you.
Thank you, Mr. Justice Carpio.
Yeah.
Because my name was mentioned many times
Oh,
about
okay.
computation.
My
Justice,
apologies, Justice Peralta.
So I want to ask another question on computation. Yeah. The computation of DMCI is that it could build something like 18 stories, right?
That
is their
appears to be, Your Honor, their position.
that is their computation.
Yes,
But my own computation is that it could not go beyond 7 stories.
I agree with your computation. Your
Because the maximum allowable building footprint based on the computation is 4,485 square meters, right?
Yes,
Yeah.
Your Honor.
Whereas DMCI use 1,639 square meter as the building footprint.
Yes, Your
Yeah.
Honor.
Do you know what we mean by allowable building footprint?
In fact, that is, I think, the
Okay, I will give you the
the
meaning.
creation of DMCI.
I will give you the meaning. It is the resultant area established at grade level upon which the proposed building or structure may be erected. So that is the area that will be covered by the whole building. So do you think that the MCI will have an allowable building footprint of 1,639 square meters with an area of 7,474 square meters?
They might have to explain how that's possible,
Yeah,
Your Honor, in their memorandum.
That's why I want to be clarified, because the maximum building footprint is actually the area covered by the building when it's already already built.
We believe, Your Honor,
yeah,
just like in your
the
computation.
area of the area is 7,474 square meters.
Yes, Your Honor.
From my computation, the allowable building footprint is 4,485 square meters. So that's the maximum that they can cover for the whole building.
Okay.
The reason is they will have to respect the setbacks provided for the National Building Code and the City Ordinance. That's why there is a difference of something like 3,000 square meters. That will be utilized for the setbacks. Now, if you use 1,639 square meters at the footprint, then there will be something like 5,800 that will not be utilized by the developer. That will be, do you get what I mean? If the footprint is merely 1,639 square meters, then there is something like 4,900 or 5,900 square meters that will not be utilized. That's why their computation, to my mind, is if you use a footprint of 1,639 square meters, you can build 18 stories. But there will be a lot there will be a big area that will not be utilized.
Yes, Your Honor, in fact,
But that is their choice. They are the builders. If they believe that that is profitable to them, then we cannot do anything.
yes, Your Honor, assuming that is how they intended to build Torre de Manila, I'm not sure if that is in fact how they built the Torre de
But
Manila.
we can make a but we can check this based on the as-is plan or later on the as-built plan that will be submitted
yes, Your Honor.
later on when they
Yes.
secure the occupancy permit.
Yes,
So
Your
that can be verified. If
Yes.
indeed their footprint is really 1,639 square meters.
Yes, Your Honor. In
Thank
fact,
you.
the standard formula doesn't require the footprint as a factor in the computation of the height as well as the FAR.
I believe this is what they submitted because this is what I got from the records, that their footprint is 1,639 square meters. Thank you.
Thank you, Mr. Justice
Justice
Peralta.
Velasco.
Mr. Solicitor General, I would like you to enlighten me on certain factual issues since the court is now being asked to look into factual matters. Do you admit that DMCI was given a zoning permit? That's correct.
Yes, Your Honor.
Okay, that was issued June 19, 2012, correct?
Yes, Your Honor. That is a void
and
building permit.
What
Zoning
office issued the zoning permit?
CPDO, Your Honor, the City Planning and Development Office.
Okay, and that office can only issue a zoning permit if the proposed structure complies with the zoning ordinance and land use plan. Is that correct?
Yes, Your Honor. He has jurisdiction to issue a zoning permit or locational clearance for all compliant uses or conforming uses.
Okay, so when DMCI was issued the zoning permit, the office, that particular office, found that the structure, the plans and specifications for this structure complied with the zoning ordinance and land use plan, which is Ordinance 8119. Is that correct?
I don't know, Your Honor, but on the zoning permit, Your Honor, is a one-page document. And you can, in fact, with your head, compute the FAR, and on its face, it clearly violates the zoning ordinance already. And so 97,549 over 7,475, this is definitely way beyond FAR of 4. And so on its face, Your Honor, it's a patent nullity.
Okay, but once a zoning permit is issued, it is assumed that that office, which is what? The CPDO?
Yes, Your Honor.
City Planning and Development Office scrutinize the plans and specifications and saw to it that all these things comply with the zoning ordinance. That is the assumption, of course, correct?
Well, that is the assumption, but on the face of this particular zoning permit,
No, I'm not
it's
talking
obvious
about
that they
what you
violated
think.
the
Okay,
law.
I'm sorry,
Yes.
but let's
Thank
just
you.
proceed
Sorry,
from
Your
there.
Honor.
Okay, so there is that presumption that the CPDO acted regularly and in accordance with the pertinent laws and ordinances. That's the assumption. That's a presumption of a building official, correct?
We cannot make that assumption
There
with
is
respect
no
to this
presumption
case.
like that, that the moment a government official performs a job assigned to him, that it is assumed that he performed his job in accordance with the law, pertinent laws and ordinances and rules and regulations. There is no such presumption?
There's a presumption ex ante, but you cannot apply that presumption ex post, Your Honor.
Okay.
Prior to his acting, you can make that assumption that every time he officially acts, he will perform his functions. But the moment he issues a document that on its face is void, you cannot use that presumption.
Okay, if you're a private citizen and you go to a government office and you ask for a permit and it was issued to you, are you saying that you will still question a permit which you sought and which was approved by a government office like the CPDO?
Thank you, Your Honor, for the opportunity to explain this particular
No,
point.
I'm asking
If-
you. I'm
again,
asking you because if you apply for this zoning permit and this was issued to you, and you're saying that you go back to the office and say, I'm returning the zoning permit because I think on the face of the zoning permit, there is a violation of the pertinent laws and ordinances.
There
Will you
is
do that?
There is a difference, Your Honor, between a private citizen constructing his first or second house and a corporate giant in the business of constructing. Your Honor, if I were a private citizen building my first house, I get a permit from the CPDO that is non-compliant. I probably have the right to rely on that particular permit. But this is a corporation in the business of construction, Your Honor. They know what they are doing. So the moment they went to the CPDO, either they knew or ought to have known that the zoning permit that they got was void. Because what they ought to have known is that they should have gone to the city council at the time, which was, of course, opposed to their construction.
Okay, so you're saying there's a different standard for an individual who applies for a permit, zoning permit, and a giant corporation who's applying for a zoning permit, correct?
Yes, Your Honor, absolutely.
No,
in this
I'm
case.
asking you because you're saying that the giant corporation has a bigger responsibility to see to it that the plans and specifications are in strict compliance with pertinent laws, ordinances, and regulations. That's what you're saying, correct?
Your Honor, I think this was highlighted during the first oral arguments about the due diligence that ought to have been performed, that is ordinarily performed by investors such as DMCI. If I were, again, a citizen who doesn't know any better, applying for his first permit, has a right to rely if he gets a zoning permit. But a corporation in the business of constructing buildings such as this, they have a department that ought to know, in fact, probably should have known, that when they went to the CPDO, they were gunning for a void permit.
Okay, as Solicitor General, can you cite a specific case where the Supreme Court made two standards, separate standards, for a private individual dealing with a government office and a giant or a private corporation dealing with the same office? Have you
Top of my head,
encountered
Your
such
Honor,
a case?
the taxability of certain transactions, if it's a
No.
one-time
My
sale
question-
of
Excuse
a
me.
person who's not in the business, then a
Mr.
different tax
Solicitor
rate
General, the
applies.
question is simple. Have you encountered any Supreme Court case that laid down that standard, that ruling, which should have guided the DMCI in dealing with the CPDO regarding their proposed project? Is there such a Supreme Court case?
There is no need for such a case
No,
because
you
everyone is
answered the
bound by
question.
the law.
As far as your knowledge goes, you just tell us if there's a Supreme Court case, if you know.
Top of my head, Your Honor, there's none that I can think of.
Oh, okay. That's right. And DMCI is saying, had the CPDO informed them that there is a deviation from the zoning ordinance, they could have already corrected it. That's the position of DMCI, right?
That is a stunningly
And
lame excuse, Your Honor, because everyone is bound by the ordinance. They cannot say that because the CPDO violated the statute, then they can rely on that violation.
Okay.
In the
But-
same way that a private
Alright.
citizen getting a void permit cannot rely on that void permit.
All right, so you're really coming up with a different standard now. However, okay, and DMCA is saying they relied on the zoning permit and therefore from there they proceeded to apply for a building permit.
They have no
Were it
right
not-
to rely
Excuse
on a
me,
void.
were it not
Sorry.
for the reliance on the official action of the CPDO, then they could not, they should not, they would not have proceeded to getting the building permit. Is that the position of the MCI? Correct?
I think that is their position.
All
Your
right,
Honor.
okay. This position that you have taken, supporting the petition, what is your basis for saying that the sightline of the Rizal Monument should have been preserved? You're saying there is no basis whatsoever for your contention that the sightline of the Rizal Monument should be preserved?
What we're saying, Your Honor, is that when the statute says conserve, when the statute says preserve, that includes, by necessity in certain cases, the protection of a sightline because that is the underlying discipline of heritage conservation. And so if I say preserve this painting, what I'm basically saying is do everything so that you can conserve the paint. And that will have to require me to control the temperature of that particular environment where I place that particular painting. A monument is meant to be seen. You cannot separate a monument from the environment in which it is situated. Some monuments have sight lines, like the Washington Monument. Some monuments do not have sight lines, like the Bonifacio Monument. In the
Alright,
case of the Rizal Monument, there is no doubt that this particular monument has a sight line.
All right, okay. Okay. There is a definition in Noah Webster's Dictionary of Sightline. Okay. A straight line extending from the eye of the spectator to an object or area. It is a straight line from the eye of the spectator to a certain object or area. So, What do you mean by that? Applying it to the Rizal Monument?
I think that that straight line is a straight line with the use of the vision of the human eye, not just a straight line, which is a theoretical line from point A to point B. And so the sight line, Your Honor, would be if you stand in front of the Rizal Monument, do you see any impairment? There's none in that particular photo, in that particular
So you
photo.
agree that from where the spectator stands up to the Rizal Monument, there is no obstruction with respect to his sight line, correct?
In this photo, Your
As
Honor,
per the
there's none.
definition of in Webster's dictionary,
I don't get your point, Your Honor. Sorry.
the sight line that is defined in the dictionary is merely the straight line from the eye of the spectator to the Rizal Monument, and nothing more.
No, Your Honor. The sight line is what an ordinary human being with the angle of his vision can see when that person stands in front of the Rizal Monument. And so our line of sight is not from point A to point B, but actually from an angle. And I think that is about 35 millimeters.
Have you personally went to the Rizal Monument
Several
lately?
times, Your Honor.
Okay.
Several times.
You're aware that there are posts connected by steel chain, correct?
Yes, Your Honor.
Okay.
To
and,
prevent you from touching the monument, I suppose.
Did you notice that there is actually a straight line which is really made up of the square tiles right in the middle of the monument? Did you notice that?
I'm sorry, Your Honor, I didn't notice it.
Okay. Can you flash the screen? Because there is a picture there which shows the barrier, no? Can you flash it and locate that picture? More. Another.
I
not
think the barrier was removed in that particular
There's another
photo.
one. There's another one showing the barrier. Another. There, you see the barrier there? Okay? Yeah. The one in front, the front portion of the bottom portion of the picture. You see that? People cannot go beyond that. Okay? And if you stand, because I went there personally, I stood behind that barrier. I stood where that straight line is, and the torre is just below the platform of the statue of Rizal. It's practically is quite small from that point, and it does not really affect the sightline of the monument itself. If you visit that clearly, you see the three soldiers walking there, the one in the middle, that is where the straight line is. Right at the center of the Rizal Monument. And you cannot practically see the Torre de Manila because it's just behind the platform where the Rizal statue stands. So it all depends on where you want to take the picture, because we have seen so many pictures, and sometimes the Torre de Manila appears to be quite tall up to the height of the obelisk. When if you go there, you will find out that the structure is quite small if you take your picture just directly in front of Jose Rizal. So what I'm saying is so relative, right? It all depends on where you stand, as just pointed out by Justice Carpio.
What I would say, Your Honor, is that the level of impairment can be rather subjective. But if you stand in front, you will see in front of the monument, you will actually see it. And the level of outrage of the people in this particular case, I think, attests to the fact that the monument has been impaired. If we're looking at some residual impairment, then this might be just a real novel case. But again, Your Honor, the court can take judicial notice of the fact that people were so outraged by this particular construction, which is why we have this case, which is probably why the court has spent 6 sessions of its precious time to hear this particular case, because the court hears the outrage of the people here.
Okay, Counsel. What particular law are you saying that points to the protection of the sightline? What particular law or rule or are you referring to the guidelines issued by the National Historic Commission of the Philippines?
Well, if we're referring to the guidelines, Your Honor, I would say that the NHCP is naturally bound by its own guidelines. It doesn't have to publish those guidelines to be bound by its own guidelines.
No,
But if
I'm
we're
saying,
looking
is
at the
that
law, Your Honor,
one applicable to the problem here, to this
It's-
particular petition? It is the guidelines? Are
it's
you-
Section 25 of RA 186 in relation to 186 provision with respect to conservation, Your Honor. I can read to you
Okay.
again the statute.
Section 25 of RA 166 refers to the physical integrity of the national cultural treasure or important cultural property that is found to be in danger of destruction or significant alteration from its original state. Is the Rizal Monument now in danger of destruction or significant alteration?
It's
Are
a
you
question
saying
of
that?
how you interpret the provision, Your Honor. What
So
we're
you're
saying is,
interpreting the provision of law to apply to this case.
Yes,
There
of
is
course, Your
no
Honor.
there is no explicit provision saying that this sightline or the Vista Corridor or the Vista Points pertaining to the Rizal Monument have to be preserved. There is no specific, explicit legal provision. Is that correct? You're only interpreting the word conserve, correct?
well, that is begging the question, Your Honor. You're assuming
No. That's what you're
already
saying.
your conclusion.
No,
What we're saying,
that's your statement because you said you interpret conserve to mean preserving the sightline of the Rizal Monument. You stated that. So you're only interpreting a word in the provision of law. It is not very explicit, but you just came up with the interpretation,
if
correct?
the court, Your Honor, decides that the physical integrity does not include its sightline, that itself is an interpretation. That is a restrictive
No,
interpretation.
correct.
What
We
we're
can come up with
asking-
our own interpretation, but I'm asking your position. Okay? So, other than this interpretation of the word conserve in RA 166 or the phrase physical integrity, you have no other legal basis upon which you can base your petition to seek relief from this court.
We believe, Your Honor, that is more than sufficient. That if the court decides to choose the interpretation that we're asking from the court, then there's nothing else that the court will have to do but to order the removal of Torre de Manila.
You mentioned mandamus, a writ of mandamus. What particular agency are we going to compel to implement the disposition that we will make in this case? What particular agency are you referring to?
Your Honor, at the first level, the moment the court declares Torre de Manila as an illegal construction, there's no need to mandate anyone other than the corporation that built it, the illegal construction, to demolish that
Can the
construction.
writ of mandamus compel a private company?
The court can declare, Your Honor,
No,
that
under
the
the
Torre de
rules.
Manila is an
Rule
illegal
65.
construction.
Can we compel a private party, a private
There is-
individual?
There is no need, in fact. The moment the court declares that the Torre de Manila impairs the sightline of the Rizal Monument, then by simple application of the law, that building will be declared as an illegal construction. And what we're saying, Your Honor, is that to aid the court in ensuring that its decision is fully enforced, it can, by way of continuing mandamus, order the City of Manila and the concerned cultural agencies, even the NHCP, to oversee that particular demolition.
You mentioned continuing mandamus, and I was the one who penned the
Yes, Your
concerned
Honor.
residents of Metro Manila
We are
versus
aware
the
of that, Your Honor.
MMDA. And I just want to elucidate that, of course, there's a standard in the decision because the disposition is to restore the water quality of Manila Bay to classification SB, which is that the water quality of Manila Bay should be good for swimming and other physical recreation. And in that case, we issued the writ because these specific government agencies, the 10 government agencies, were compelled to perform their specific duties under the law. So these are government agencies, and we just require them to do what they're supposed to do under the laws, okay? So, but in this case, you're saying that we issue a writ of mandamus, and you're saying we even issue a writ of continuing mandamus. A continuing mandamus refers to compelling an agency to perform a series of acts until the goal is attained, okay? So, I don't know if we can really issue the writ of continuing mandamus or even the mandamus.
In fact, Your Honor, the case that you penned applies pound for pound for the case that we are considering here. These cultural agencies, as well as the City of Manila, have the legal obligation to protect cultural heritage. That's under 166, 186, as well as the local government code. And so, by requiring them, by way of continuing mandamus, to oversee the demolition of Torre de Manila, you're requiring them to perform their task, which is to ensure that the impairment to the Rizal Monument is eliminated.
Okay, you're
it's that
saying the
straightforward.
City of Manila can be compelled to do certain things which are provided under the law. But you mentioned a while ago that it's only Republic Act 166 that says it should be conserved and it should be interpreted to mean it also includes the preservation of the sightline and even the physical integrity. Okay, will that be a sufficient basis to compel the city legal officer or the City of Manila
Your Honor,
to what? To demolish Torre de Manila? Is that what you're saying?
to oversee the demolition. The
Oversee.
entity, Your Honor, that is responsible or that should be responsible for the
Oversee.
demolition should be the entity that illegally constructed in the first place. Not
So
the City of Manila,
We don't have
not
to
the
issue a writ
NCP.
of mandamus. You're saying we just order DMCI to demolish their own building. Is that what you're saying?
The court can do that. What I'm saying, Your Honor, that if it really wants to ensure the prompt and judicious demolition of Torre de Manila, it can also order, by way of continuing mandamus, the national agencies as well as the City of Manila to oversee, just like in the MMDA case, to oversee that the laws are followed so that the water quality of the Manila Bay reaches its legislated water quality.
The difference in that case is that it is the Supreme Court Manila Bay Advisory Committee which oversees the implementation or the compliance of the 10 government agencies with their respective legal duties under the law. But anyway, your allegation on the sightline, on the Vista corridor, on the Vista points, are these found in Ordinance 8119, which was issued in 2006? Can you find those provisions there?
The ordinance, Your Honor, I'm not sure if it's there,
You're
Your Honor.
not sure, okay. Probably not.
But there's actually an ordinance that was passed as a
But-
consequence of this controversy.
But this was not approved or signed by the city mayor,
Well, that's
right?
another interesting question, Your Honor, because the city mayor can veto an ordinance only if it is ultra vires. But the regulation of heights of buildings, Your Honor, is not within the power of the city mayor. It's within the power of the Sanggunian itself. And so there's actually a case for declaring that particular veto as unconstitutional as well.
Okay, you're saying you admit zoning permit was issued, okay, and that the building permit was issued, and then later on the city council issued, I think, 2 ordinances questioning now the compliance with the zoning ordinance, correct?
Your Honor, it's clear that they did not comply. The fact that they
I'm
asked
just
for an
asking you if there are
exemption.
2 ordinances. We're just laying the premise. Okay,
Can I just intervene? It's already 6:25, Council. Can you just please answer directly? because we are really running
my
out of
apologies,
time.
Your Honor.
Please,
I think-
if the question is answerable by a yes or no, then answer it in that manner.
Okay.
Because it's
I will attempt to do that, Your Honor.
Okay,
It's just
please
that
do
some
that.
questions require
Give your
some
level
elucidation.
best.
I will do my best, Your Honor.
Okay.
Thank you.
Now, because of these two ordinances, DMCI applied for a petition for the approval of the variance, right?
I'm sorry, Your Honor. I'm
Variance.
sorry.
It
Again, Your
applied
Honor.
for the change of the works or variance in the plans
It-
and specifications, correct?
In fact, it did not apply. It simply sent a letter.
It did not apply.
Did not apply for a variance. There was simply a request for assistance. DMCI has not provided us with a formal application for variance.
Okay, okay. Nevertheless, was this acted upon by the Manila Zoning Board of Adjustments and Appeals? This was acted upon, correct? This
That-
was
that
acted
letter
upon. And the
request.
variance was approved, correct?
Yes.
It
Your
was
Honor.
approved.
Yes.
Okay. What is the effect of the approval of the agency provided under the zoning ordinance? Of a variance of a work that was previously subject of a zoning permit and a building permit issued by the city government of Manila. Is that curative? Because the wording there is ratify and affirm the previous
The ordinance, Your Honor.
permits, licenses, and approvals. So it tends to cure whatever problem there was regarding the zoning permit and the building permit.
You cannot ratify a void permit, Your Honor. In fact,
Well,
if they did that, they would be allowing, just like our friend in the South China Sea, DMCI to create facts on the ground and therefore take advantage of their violation of the ordinance to load the dice in their favor and make it difficult for the court to order the demolition of Torre, when in fact they have no right to build in the first place and have taken advantage of void permits precisely to, well, like I said, create
All right,
facts on the
but you
ground.
must admit that the ruling and the decision of the Manila Zoning Board of Appeals and Adjustments is that it ratified and confirmed all previous permits, correct?
That is the wording of the ordinance.
Correct, correct. And what is the effect of that? It tends to cure the whatever problem there was before,
You
right?
cannot ratify a void zoning permit or a building permit.
You're saying it's void.
It is, Your Honor, because the CPDO had no authority to issue that permit in the first place.
And so are you saying the people who issued this may be administratively or even criminally liable? Is that, what you're
That is
saying?
not for me to say, Your Honor.
Oh, but you're saying they issued a void permit.
Yes, Your Honor.
Okay. That's all, Chief.
Counsel, may I again request, please, direct answers, because really the court wants to conclude
Yes, Your Honor.
these oral arguments as soon as possible. Now, you are Solicitor General, and I am aware of the statutory mandate of the Solicitor General under the revised Administrative Code. And I read your power to mean that first, you of course presume constitutionality of statutes, and with respect to statutes, that is where you get your mandate from.
Yes.
Okay? So that if a specific officer has been granted a mandate to make a determination on a matter, then you will defend that mandate, correct?
Yes, Your Honor.
Okay.
As a general rule.
Now, can I request you to look at Section 5, RA 10086? Okay? Can you please read it? And what is it? Can you read the title first and then the section?
General mandate,
Okay. Of what?
the NHCP.
Of the National Historical Commission of the Philippines. And what is the mandate?
Conduct and support all kinds of research relating to Philippine national and local history.
One, primary agency responsible for history.
Yes, Your Honor.
And the authority to determine all factual matters relating to official Philippine history. Am I reading it correctly?
What particular section, Your Honor?
Section 5.
Section 5, paragraph. Okay, yeah, I get it.
Okay? I'm reading it correctly.
Yes, Your Honor.
So, it is only the NHCP that has the authority to make any factual finding on all historical matters, correct?
That is true, Your Honor.
Okay. Now, with respect to the National Commission on Culture and the Arts, can I ask you to read Section 8, RA 7356? Why was the NCCA
the commission-
created?
A National Commission for Culture and Arts is hereby
Yes.
created to formulate policies for the development of culture and the arts, implement these policies in coordination with affiliated cultural agencies, coordinate with the implementation of programs of these affiliated agencies, administer the National Endowment Fund for Culture and Arts, encourage artistic creation within a climate of artistic freedom, develop and promote the Filipino national culture and arts, and preserve Filipino cultural heritage. The Commission shall be an independent agency. It shall render an annual report of its activities and
Okay,
achievements to the
that's good
President.
enough. All right. So there is a major distinction between the jurisdiction of the NHCP and that of the NCCA. While the NHCP has been given the authority on all matters relating to Philippine history, the NCCA is mandated to formulate the policies for the development of culture and arts, correct?
Correct, Your Honor.
Okay. And that in this capacity, it shall coordinate with the national cultural agencies. Is that correct?
Correct, Your Honor.
All right. So with respect to the question of the Rizal monument and factual matters relating to what is necessary to carry out the mandate under the relevant statutes, it is the National Historical Commission that has that mandate, correct?
On factual matters, yes.
Okay. So why did you drop an HCP as a client?
Because we had a difference of opinion with respect to a question of law.
All right. Can I ask you to read the letter of Chairman Serena Jokno to you, starting with the second paragraph? The letter dated July 29, 2015.
My apologies, Your Honor.
You don't have it?
I have it now.
Okay, please read it.
Which part of the letter?
Second paragraph, starting with the words, "You assured me."
You assured me that the
Okay.
NHCP
All the
is-
way up to the end. You assured me that the NHCP
is cleared of any responsibility because you will explain if asked that the NHCP board members are not constitutionalists. But the draft of your statement primarily cites Section 25 of the Heritage Law, not the Constitution, as your legal basis. We read this provision and understand it exactly as it is stated. When the physical integrity is found to be in danger of destruction or significant alteration from its original state. Even the petitioner admitted during the oral argument last week that this provides no legal basis for the stoppage of Torre. Now you say there is.
Go ahead.
So if the basis of your prayer that the NHCP be discharged as a respondent is gone, on what grounds then should we be discharged?
Okay, you can skip the next paragraph, then go ahead with the next one.
Make no mistake, the NHCP did not and does not like the Torre. But as a responsible government agency, it does not and will not act on grounds of personal preference, but solely on the basis of law, in this case, the Heritage Law and the NHCP Charter.
Go ahead and read the next two paragraphs.
The implications of your new position will go well beyond the NHCP's position. They are immensely worse for the nation, particularly in terms of the rule of law, the right of the present generation to create its own heritage alongside that of earlier generations, and pending heritage cases, among others. You insist that the case at hand is sui generis, Yet I asked earlier what would happen if the torre were demolished and the landowner behind it were to construct another tall building. Would that be another sui generis? And how are we to respond to other heritage cases that will likely appeal to us on the same grounds? You advised me not to worry about future cases, that you would be around to defend us. But if you change your mind again in the middle of a case, what are we to do?
All right. This again is a dilemma that we are facing here. You have dropped NHCP as your client because your NHCP is insisting on its mandate to make a pronouncement on historical matters. And by statute, the NHCP has the historical mandate, as the statutory mandate, to make a pronouncement on the status of the Rizal Park, as well whether any reference of an opinion, advice to it in relation to our cultural laws, it has the right to make an opinion on the matter. Is that correct?
If I may respond, Your Honor.
All right.
This case, Your Honor, is about statutory interpretation. It's not about whether
All
or
right.
not some fact
Your former
is
client
contested.
is saying that we read it as it is, Section 25. All right. Now, we have, under the rules of statutory interpretation, the basic rule that when a provision of law has a plain meaning, unless there is a technical meaning, then you apply the plain meaning of the law. That's basic. That's statutory construction 101, correct?
Yes, Your Honor.
Okay. Now, you are asking this court to define physical integrity as something else.
No, Your Honor.
Oh, okay. Can I read to you what is the plain meaning of physical integrity? And this is from a basic textbook, Merriam-Webster Dictionary. And
It's not a legal
pardon.
book, Your Honor. Sorry.
We use ordinary and plain meaning. All right. That's basic to us because we cannot expect the legislature to not intend plainly what they have set out in plain law.
That is
Okay?
not the case here,
Okay,
Your Honor.
all right. Let me finish.
My apologies.
Merriam-Webster refers the physical integrity of an object refers to the physical properties and composition of an object. Now, with respect to physics, it's the science that deals with matter and energy and their interactions in the field of mechanics, acoustics, optics, heat, electricity, magnetism, radiation, atomic structure, nuclear phenomenon. Also, physical processes and phenomena as of a particular system, and the physics of properties and composition of something. All right. I have to divine what led you to take this position, that first, the NHCP is not the authoritative body under the statute that the Solicitor General should listen to. Remember that because you're attacking the NHCP's position, you are also basically saying that the NHCP acted ultra vires in making that letter address to, I don't know, was it the Office of the President? When it said that there is absolutely or there is no objection.
That was addressed to the City Mayor's office.
To the
Your
City
Honor.
Mayor's office, all right. Here you have a statutorily mandated agency reading the law plainly for what it says. And you are saying you cannot read the law that way. What gives you the basis to tell NHCP that had for years been discharging its duty under a straightforward reading of the law that it is wrong?
May I respond, Your Honor?
All right.
Thank you, Chief Justice. Our position, Your Honor, is not to attack the NHCP. We simply have a disagreement with respect not to a question of fact, but with respect to the meaning of the law. You say, Your Honor, that the law should be read plainly. What we're saying, Your Honor, is that the law was passed in consideration of the practice of conservation. And when you talk to those who do the practice of conservation, they will tell you, and the documents will show, that the practice of conservation covers, in certain cases, the protection of the sightline. And this is not a novel idea. In fact, it is a practical idea.
Okay.
And that is what we admit that
So
we have
now
overlooked.
you're asking this court before it does anything with respect to this case, to not go to the legal standards that the NHCP in fact did not even see, but to consult with practitioners on the matter of what the legal standards are.
In fact, Your Honor, that is what perplexes us. At the beginning of the case, everyone was agreed that Torre de Manila, or at least with respect to NHCP, they did not like Torre. It's just that they did not have the legal arguments. And so when we said that we had the legal arguments and that those arguments can be presented as questions of law, as straightforward interpretations of the law, our expectation was that everybody would be happy that they now have the legal arguments to back up their political beliefs. And so, honestly, Your Honor, I'm really still surprised that the NHCP would insist on a legal interpretation that impairs it from
But,
acting on a cultural disaster.
You know what it said in its letter, effectively? And it's very clear what it was trying to tell you. All right. The implications of your new position go well beyond the NHCP's position. And mark this is a very thoughtful paragraph. They are immensely worse for the nation in terms of the rule of law, the right of the present generation to create its own heritage alongside that of earlier generations. It resonates of the line of Justice Leonen that speaks of a diverse nation and pending heritage cases, among others. You insist that the case at hand is sui generis. Yet I asked earlier, what would happen if the Torre were demolished and the landowner behind it were to construct another tall building? Would that be another sui generis? And how are we respond to other heritage cases that will appeal to us on the same grounds? You advised me not to worry about future cases and that you would be around to defend us. But if you change your mind again, in the middle of a case, what are we to do? Okay, so this is a worrying problem for me because right now you just dropped also one of the major claims of the NCCA. Do you read the statutory mandates or of the agencies as they are? Or are you basically saying you can interpret them any way you can?
May I respond, Your Honor? I'm not really sure whether the NHCP is claiming that Torre de Manila is a future cultural treasure of the nation. I hope they're not making that particular claim. What we were telling the NHCP simply was, we now have the interpretation to allow you to act reasonably with respect to a disaster, which is the impairment of the sight line of the Rizal monument.
But you know,
And
you
so
are
when we-
basically going to compel this court to rule. You are basically asking us to come to the conclusion that the NHCP acted in grave abuse of discretion when it said that there is nothing in the law that will allow us to object to the construction of the Torre de Manila. When we say that actually the NHCP was wrong and we should read Section 58 in connection with the practice of heritage conservationists, and then we read it in accordance with their very novel practice of what is physical integrity and physical deterioration and physical destruction, we should have a new meaning completely which is not found in any dictionary. You are still wanting us to say that the NHCP did something terribly wrong. And the conclusion is basically that they are not discharging their statutory mandate, that they, the protectors of the history of the Filipinos, are the ones who are basically acting in a manner contrary to that historical interest. And you understand that that is a serious, serious implication for you to make against the NHCP.
May I respond, Your Honor? Our position, Your Honor, is that the NHCP itself in its guidelines have norms that are protected of vista, corridors, and of sight lines. And so they are bound. That is their own interpretation of how to
But
protect
you
the
see,
monument.
they
Your
made
Honor.
an interpretation in the letter to the city, office of the city mayor. That is their interpretation. Now, what gives the Solicitor General the right to contradict the interpretation of the NHCP of its mandate?
The Solicitor General, Your Honor, is counsel for the entire government.
No, you just laid bare to us effectively that you were spurred not by your reading of the statutory mandate of your former client, but it was because you were influenced by two opinions of two private individuals who derived their authoritativeness not from the law, which is the source of legal authority as far as we are concerned, but from their own progressive perspective. Is that a correct position for a Solicitor General to make?
May I respond? Your Honor?
Yes.
If I had read a newspaper article and became influenced by an article in a newspaper and decided to change my position, it would be the same thing, Your Honor. What I simply did, Your Honor, is to talk to a lot of people, to talk to people who are more versed in the area of
And
heritage
in that
conservation.
process, you contradict your client simply because you consulted many people. And you were not careful to observe that Congress entrusted the NHCP with that mandate.
Your Honor, the question here
Do you
is
always
how...
do that for your clients? And who would trust you afterwards?
May I respond, Your Honor? We do this, like I said before, regularly.
All
Your
right,
Honor.
you are basically making a serious statement here. You are basically saying that on a general practice basis, the Office of the Solicitor General drops its clients anytime and contradicts its clients anytime and adopts conflicting positions at any time. Is that the statement you're making?
When it is required by a particular case.
Is it
Can I-
always required? Because the amount of instances that you were citing to us seems to be enormous. So it is always required.
Well, in that case, we will lose all our clients if it's always required. Your Honor, if I may explain.
Yes.
I'll give you an example, Your Honor, with respect to an expropriation case. A judge rules that a parcel of land should be expropriated for 20,000 pesos. In the judgment of the Office of the Solicitor General, when we believe that the amount is very high, even if the Department of Public Works and Highways believes that that amount is okay, we, in
But
certain
the
cases,
law
even
does
file.
not give the Department of Public Works and Highways the authority to determine the valuation. It is always a judicial matter that will be contested. The problem here is very different. Here, the law gave the NHCP exclusive power to determine all factual matters relating to Philippine history.
This is not a factual matter, Your Honor. This is a question of interpretation. Totally
Now,
not a fact.
the-
We're not determining birth dates. We're not determining the age of a monument. We are determining what type of interpretation should be accorded to a particular term in the law.
What about the National Museum? You have espoused the position of the National Museum.
The National Museum is with the
Yes.
Office of the Solicitor General.
Okay, does the National Museum have the authority to make a pronouncement on matters of history, or is it primarily mandated to conserve and promote artifacts and documents, etc.?
Under their charter-
Can you please read the charter of the National Museum in reference to Section 13, PD 374, and Section 663, RA 8492. As a cultural center, can you read it? It shall take the lead in the study and preservation of the nation's rich artistic and cultural heritage, in the reconstruction and rebuilding of our past, and the development of the national cultural wealth. All right? So with respect to national monuments and national parks, it is not the National Museum. Because under Section 5 in RA 10086, it is the NHCP that shall manage, maintain, and administer national shrines, monuments, historical sites, edifices, and landmarks of significant historical cultural value. And it is the one that can undertake and prescribe the manner of restoration, conservation, protection of the country's historical movable and immovable objects. All right? Now, you have an immovable object there in the Rizal Shrine, that has been constructed for the purpose of permanency.
Your Honor, it's the monument, not the shrine. Those are
Okay,
two different
monument,
things.
right. That, well, the KOR might dispute you on that. So there is permanence there, and the administration and management is given to the NHCP. Why, in this particular instance, did you drop NHCP and not have the same view with respect to the National Museum?
Honor, the NHCP, I think, believes that they cannot do anything legal insofar as protecting the sight line of the Rizal Monument. What I'm simply saying is that
Okay,
the
now
law
let's, I know,
allows
okay,
them to do that.
so I understand now. On the other
Thank you,
hand,
Your Honor.
because you basically saying that it is not progressive and radical enough, that's why you could not comfortably have them as client.
I'm not asking them, Your Honor, to be progressive or even radical. What I'm simply saying, Your Honor, is that their guidelines, which allow the protection of sight lines, can be used as a justification for protecting
But they
the
just
sight
said
line.
that they don't find it enough justification. Because it contradicts a formal finding on their part, a finding of fact, and a
No, Your
finding
Honor.
of fact that under the statute that created them, they had the mandate to make. The National Museum does not have that mandate. Why did you now drop National Historical Commission's position and adopt national museums?
Your Honor, because my belief is that
Because you thought that you could still advance and use the guidelines as legal basis. But the NHCP does not believe that. If the NHCP itself does not believe that the guidelines provide a legal standard for them to make an act, what gives you the authority to say that it provides a legal standard when the NHCP itself says it does not?
Can I respond, Your Honor? Thank you. Again, Your Honor, this is not an interpretation of fact. This is an interpretation of the statute. What we are simply saying is that the statute can be read, and in fact should be read, to allow the NHCP, to empower the NHCP in certain cases to protect the sight line. We are not inventing something new because the guidelines of the NHCP itself require the protection of those sight lines.
But
Now, if
under,
they believe,
under the specific question that they were asking for, a question, a matter of fact, they already made a pronouncement. Now, what gives you the authority to contradict the statutorily mandated office to do that?
Can I respond, Your Honor? Again, as I was saying, this is not a dispute with respect to the age of a monument.
I have heard that. I have heard that. Okay, we have all been this entire evening, you have been talking about what is not fact and what is just law, and as if we can just say that the law allows what? And we have been asking for standards all this time, and you have not provided us any standard. Now, let me now go to my next line of questioning. The NCCA, under the statute creating it, is a coordinative body, principally, vis-a-vis the other agencies, correct?
Yes, Your Honor.
Okay, and then it creates it formulates policies, but it does not, under the statute, have the power to make a determination of fact. Is that not correct?
Don't think so, Your Honor.
Okay, in fact, under its own rules, jurisdiction of the NCCA, when it says it can issue a cease and desist order, it only says that it can issue CDOs only in relation to properties declared as World Heritage Sites and works of national artists. And it can also make a declaration with respect to nomination of sites to be declared as World Heritage Sites. Is that not correct?
That is correct.
Oh, very clearly, the NCCA's mandate is very limited. The NCCA's mandate is very, very limited to WHS sites and also to works of national artists. That's very clear. Culture
We
and
are
arts.
not disputing that.
National Museum also very clear. Now, with respect to these three agencies, it is only the NHCP that has a direct bearing on the matter. And yet you disregarded its opinion and adopted an opinion that is very, very different. Okay.
May I respond,
That
Your
will,
Honor?
Are you always in the process of doing that? Is the Solicitor General authorized, whether under the administrative code or under the code of ethics, professional ethics, to not act as the statutory counsel of an agency even when an agency is saying that it is just exercising its mandate?
Your Honor, if you want, I can provide you with a rather long list of cases where we have withdrawn as counsel. I'm sure members of the Honorable Court are very familiar with that practice where the Solicitor General, in certain cases, when it disagrees with the client agency.
This is now what I need to find out. This court has the power to regulate the profession of law and the practice of law, and you are a practitioner of law. Are you now saying that with respect to you, we are bound to take judicial cognizance of the fact that you are free to break the code of professional ethics?
Your Honor, what I'm saying is that I am
Do you have
allowed by
guidelines on
law.
that? Do you have existing guidelines and when you drop a client and when you do not?
I think, Your Honor,
Is it just a matter of personal preference, as Chairman Jokno was asking?
Can I respond,
Yes.
Your Honor? Every public official who is vested with discretion to act in a certain matter, in certain cases, will have to exercise that in his best light. And the
Yes, we
jurisprudence
can
of
always
the
make
court,
that claim. But there are objective parameters and there are limitations to the claim of the exercise of discretion. Simply because you are counsel does not mean that you can ignore existing statutes.
may I respond, Your Honor? So far as I am aware, this is the first time that a member of the court has questioned the authority and discretion of the Solicitor General to disagree with a client agency. That authority, Your Honor, is deeply embedded in the court's own jurisprudence. In fact, in certain cases, the court has even prodded the Solicitor General to act as the tribune of the people when there is a need to disagree with the client
Okay,
agency.
whose tribune are you now? If the statute itself says that the NHCP is the one with the authority on the matter, whose tribune are you?
Your Honor, I am representing the government. The NHCP is representing itself.
So you
through
are,
private
who is the
counsel.
government? Is it the Office of the President? Did the Office of the President authorize you to contradict the NHCP?
Your Honor, the government.
Who
has
is
an
the government
instrument-
here?
The entire government machinery.
Entire
Your Honor.
government, what is the entire government machinery? Can you describe it for us? It's made up of more than 1 million employees. Are you representing them?
Your Honor, my power.
Are you representing the
derives-
City of Manila?
No, Your Honor.
Okay. Why are you not representing NHCP? NHCP, which has the statutory mandate, and the two agencies you are representing do not have the statutory mandate.
May I respond, Your Honor? Again, Your Honor, in certain cases, the Solicitor General, ever since it was created, has found it necessary to disagree with a client agency.
Okay. We know that because we know the landmark
Thank you, Your
cases when
Honor.
the Solicitor General was called the Tribune of the People.
Thank you,
Now,
Your Honor.
in your statement, you have to say why you are acting on behalf of the people when you are contradicting the National Historical Commission of the Philippines and when, in your Facebook post, according to the exchange between you and Justice Leonen, you said you found enlightenment in the opinions of two private individuals, and you did not find enlightenment from the statute creating the NHCP.
I didn't say that, Your Honor.
Well, that's effectively what happened because you were saying that you did not find the NHCP's position to continue to be tenable in saying that it had no basis to act.
May I respond, Your
Okay.
Honor? I strongly object to the statement that I am going on alone because
Then you
I
prove
decided
that.
to.
You prove that in your memorandum. We want a complete list of cases that you dropped your clients and your justification. We want to prove that this is not discretionary and arbitrary on your part, but this is founded on significant legal reasons for doing that. And I want you to openly declare before the court if you had acted on behalf of an instruction of any official or it is an amorphous lot that you are recalling for yourself as the source and authority for the action you have taken.
May I respond, Your
Yes.
Honor? Number one, we will provide you with a very long list of cases where the Office of the Solicitor General has disagreed with a
Plus
client
the
agency.
justification. Because you are basically giving us, these are alarm bells that are now ringing off in this session hall. You have to have justification for why you drop your clients and which particular agencies you choose over what, okay?
We will do that, Your Honor.
Okay. Now let's go to your constitutional construction. Section 15 of the Declaration of, you have basically said, Solicitor General, that in order to come to our conclusion, we have to make certain conclusions. Number one, despite the fact that the statute does not provide for sightlines, and despite the fact that the sightline here is undefined, we need to make a conclusion that Section 25, which under the language says physical integrity of national cultural treasures or important cultural properties are found to be in danger of destruction or significant alteration from its original state. Okay, you need us to make an interpretation that this includes sightlines.
Yes, Your Honor.
Okay, and you have been repeatedly asked to provide even a dictionary basis, a plain language basis, for us to say that physical integrity, destruction, alteration includes the entire vista, okay? And that you cannot now tell us the width, the breadth of that vista, the distance.
May I explain? Again, Your Honor, like I said, there's no need for the court to declare the metes and bounds, only a determination that the sightline was impaired. And this sightline, again, is a sightline that will be available to an ordinary person who stands in front of the Rizal Monument.
Right, where is it found? Your words right now, where can we find that? In any statute book.
What we are saying, Your Honor, is that the court has two options, a conservative
So we have to
interpretation
have judicial
and a liberal.
legislation. We will legislate and we will replace the legislature.
Not at all, Your Honor. In fact, what we're saying is that when the Congress passed
All
Section
right.
25,
How many
they
historical monuments are there?
I'm not aware of the exact number of monuments around the world, Your Honor.
In the Philippines?
I'm not aware of the number, Your Honor. With respect
Will
to
we now
Rizal
require
monuments,
sightlines for all of them? How far? How distant? How big? How wide?
again, Your Honor, like I said earlier, the court is not required to make a determination that all monuments have sightlines. As a matter of law, what we are simply saying is that
So we will make a ruling only for the Rizal Monument.
because the case only, Your Honor, is with respect to the Rizal
So we
Monument.
will not make a pronouncement on the pending action right now with respect to the Bonifacio Monument, Ninoy Aquino Monument.
Not at all, Your
All
Honor.
right. Now, how does it relate to the fact that when petitioner was talking about world conservation practices elsewhere, there were always monuments. Some of them are in busy city intersections. Okay? And the practice is varied. Of course, the ideal you had
And we
said,
agree, Your Honor, we agree.
you agree that there is no international standard right now.
No, Your Honor, we agree that some monuments require a sightline, other monuments do not require a sightline. The Bonifacio Monument, a lot of the monuments in rotundas obviously don't require a sightline. Here, Your Honor, just like in the Washington Monument,
Okay, who will require sightlines then? Is it this court which will be for the first time requiring a sightline?
what we are saying, Your Honor, that the court can declare as a matter of law that Section 25 empowers the NHCP to protect the sightlines of monuments. In particular, with respect to the Rizal Monument, the court can make a declaration that the Rizal Monument obviously has a sightline, and everything follows from there.
Okay, Solicitor General, we had actually agreed that we will not go beyond 7 o'clock. It is not, Justice Test, okay.
Thank you, Madam Chief Justice.
I just want to know, I know for a fact that there are instances when the Office of the Solicitor General do you also do that?
Yes, Your Honor.
So you're free to do that in the exercise of your sound discretion.
Yes, Your Honor.
Now, you know, at the very doorstep of the National Historical Commission, the city government laid the issue that there was a violation of the standards and policy guidelines issued by the National Historical Commission. In fact, that was cited by Dr. Jokno in her letter to the city
Yes, Your
government. And if I will read the resolution of the city council, it states that whereas if completed, this enormously contentious vertical concrete expansion will rise above and surely dwarf and overshadow the Rizal Shrine, and with such towering ugly bulk shall visually despoil, degrade, and cheapen the most sacred sightline and vital valuable vista of our national monument, resulting in the blatant disgrace and perpetual corruption of our heroes' lasting legacy, as well as our national identity and patrimonial pride. That was the statement of the City Council in its
Yes, Your Honor.
resolution. Do you find it strange that Dr. Jokno never mentioned anything about this violation which was brought up before the office of the
Well-
National Historical Commission?
I suppose, Your Honor, that Dr. Jokno can explain that for herself.
I asked that question because I want you to give your to discuss in your memorandum whether you feel that the National Historical Commission did not abdicate its duty in explaining whether or not this issue brought before it will really violate the guidelines issued by the National Historical Commission.
Okay, Your Honor, I will explain that in our memorandum.
The letter of Dr. Jokno also mentioned that the issue here is not about the historical significance of the site. It is not about the frontal view of the monument, but it is about the background view of the monument. And yet, the National Historical Commission was also silent if that is covered by the guidelines of the National Historical Commission. And from the documents presented to us, it would seem that this communication from the National Historical Commission became the basis for the justification in approving the variance by the city government.
I will explain that in my memorandum, Your Honor.
That is all.
All right.
Chief,
Okay. Justice Ardaleza.
I yield to Justice Leon.
Chief, may I request that the National Historical Commission of the Philippines be required to submit a memoranda with respect to the question that I asked the Solicitor General a while ago, that when Jose Rizal died, was there any instructions by Jose Rizal in relation to his burial requirements? Also that what happened after he died, how was all of this discovered? Also that the definitive history of the Rizal Monument be included in their memorandum.
All right. The National Historical Commission is so instructed. When do you want this memorandum to be submitted, Justice Leonen? together with all the memoranda. It will be a separate memorandum.
Included in there.
It should be included in the memorandum that you will be submitting. Justice Ardileza.
Chief, I have some questions for the Soldian, but it's already 7:10. May I request that, if we adjourn, I can just ask him some questions at the next session?
Okay, we will reserve the resumption of the session on Tuesday, next Tuesday, same time, with Justice Ardileza resuming the interpellation of the Solicitor General, also at 2 p.m. Thank you.